Yes.
That's one matter for 230 members. There was a temporary injunction in favor of the petitioners members, and respondents challenged before the miscellaneous appeal, and it is vacated. They are now constructing.
Yen.
Urgency is there without giving the notice. They are evicting. Orally, they are saying with the force of police they were.
Who is evicting?
Patan Panchayat.
Yav
I am the lazy for that.
Yav Patan?
From
Yav Patan Panchayat?
Rattihalli Patan Panchayat.
Yaar standing council yaar.
Standing.
Or Sarmat.
Before the trial court, tomorrow is the date fixed, my lords. The challenge in court of jurisdiction. I have complied the matter, my lords, and matter is file is, my lord, in the board branch. It is not listed. Please.
Let's one matter for 230. Delivery of possession warrant is issued.
One matter 230, withdrawal, my lords.
Withdrawal good.
Statements, page 17, 64 to 66, page 18, 67 to 70.
My lords, still number 68, my lords. I am for respondent, my lords. Inform to the other side, my lords.
2011.
Please, my lords.
Reach agala. 68 at the request of counsel for respond number 2. Challappa. Released on 11th March.
My lords.
Interim order ಏನಾರು ಇದೆಯಾ?
No, my lords.
Page 19, 71 to 74.
My lord, serial number 73, my lords. Appear on behalf of Sharna Basava, my lords. It may kindly taken next week, my lords.
Inform ಮಾಡಿದ್ದೀರಾ?
My lord, I am appearing for petitioner, my lord. Next week, any date, my lord.
Pick ಆಗಲ್ಲ.
My lord, sharp. Next week, any date, I'll take chance, my lord.
At the request of counsel for respondent released on 20th.
Meanwhile, interim order. Interim order.
Interim order earlier granted. is
Please.
extended.
Page 20, 75 to 79, page 21, 80 to 84, page 22, 85 to 91, page 23, 92 to 99, page 24, 100 to 106, page 25, 107 and 108.
Lord, with kind permission, one matter wherein the lordship was pleased to issue bailable warrant to the deputy commissioner and principal secretary. Monday.
Instruction, no?
ಅಲ್ಲ ಬಂದಿದೆ instructions and we will also file affidavit by
Monday.
ಅದಕ್ಕೆ Monday. Please.
One, the subject. Number one,
ಏನಪ್ಪ?
Noddle.
Yes, Mr. Rajshekar. You are on mute. We can't hear you.
My lords, I appeared for petitioner, my lords, but my name is shown as, my lords, representing the respondent, my lords, in the cause title.
Very, very good. Shri Rajshekar has submitted that he had appeared for the petitioner, however, in the cause title, his name is reflected as that appearing for the respondent. Registry is directed to correct the same. The reference to Shri Siddhappa Sajan at para 4
And 6, my lord.
6 would also be required to be corrected as Shri S. Rajshekar appearing for Shri Siddhappa S. Sajan. Registry is there, carry out the above correction and issue a fresh copy.
Great, sir.
Please, my lord. Petitioner, my lord.
Yes.
Writ of mandamus, my lords. Issuing the direction against the respondent. To kindly to
In direction.
My lord, they are seeking for to demark and to fix the boundaries.
OD and Duress.
Yes. Yes. Lord, pursuant to this communication, the ADLR has submitted applications to the Tahsildar, and it is the Tahsildar who has to submit through online. Now the entire process is through online, my lord.
Online ಕೊಟ್ಟಿಲ್ವಾ ಯಾರು?
ಇವ್ರು ಕೊಟ್ಟಿಲ್ಲ, ನಮ್ಗೆ ಫಿಸಿಕಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
Online ಮಾಡಿ.
We have, the ADLR has submitted the requisitions filed by to the Tashildar, and if the Tashildar submits through online, my lord, we will carry the necessary steps. Let the petitioner shall also submit through online.
Online early.
On that observation, it can be disposed of, please.
Learned AG accepts notice for
ಅಲ್ಲ ಆಗಿದೆ,
respondents.
ಲಾಸ್ಟ್ ಟೈಮ್ ಆಗಿತ್ತು.
GS served ಅಂತಿದೆ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಟೇಕ್ ನೋಟಿಸ್ ಅಂತ ಆಗಿತ್ತು.
ಆಗಿದೆ. ಬಂದೇ ಇಲ್ಲಪ್ಪ, ಇದೆ ಫಸ್ಟ್.
ಇಲ್ಲ, on when it was listed on 6/2.
ಓ, ಹಳೇದಿದೆ.
6/2 ಆಗಿ
23 ಮ್ಯಾಟರ್.
ಡಿಸ್ಪೋಸ್ ಮಾಡಿಕೊಡ್ತೀನಿ ಸರ್. ನೀವು ಹೇಳ್ರಿ ಚಲೋ.
ಅಲ್ಲ,
ನೋಟಿಸ್ ಆಗಿಲ್ಲ. ನಿಮ್ ಸಬ್ಮಿಷನ್ ಇದೆ. AG accepts notice for respondents.
1 to 4, please.
The petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the representation submitted by the petitioner on 28/7/2023 at Annexure F for carrying out 4D and Durasti of the lands of the petitioner in survey number 269/1 of Ainapur village, Atni Taluk, has not been considered and necessary action has not been taken. Learned AGA submits that the representation is not in the proper format. If an online application accompanied by necessary documents is filed by the petitioner, necessary action would be taken. In that view of the matter, reserving liberty to the petitioner to file an online application in the relevant form accompanied by the necessary documents, the petition is disposed, directing the respondent number
Lord, he has to submit to the Tashildar. Thereafter, it will be communicated.
to consider the said online application as and when filed within a period of the respondents to consider the said online application, issue notice to all the stakeholders in the aforesaid survey number, carry out a survey, demarcate the respective shares, and issue necessary documents within a period of 6 months from the date of receipt of the
Please.
application.
Please.
Yes.
It is writ of mandamus.
Copy is not served, my lords. It may be taken up in the next week. Let them serve a copy, I will tell.
My apologies.
ಏನ್ ಬೇಕು ನಿಮ್ಗೆ ಇದ್ರಲ್ಲಿ? Mandamus
A proper deed of convenience.
Conveyance.
Consider it.
Next
If he
week.
is entitled to execute it, otherwise reject it.
ಇಲ್ಲ ಮೊದಲೊಂದು ಏನೋ ರಿಜೆಕ್ಟ್ ಆಗಿತ್ರಿ ಅದಕ್ಕೆ ಈಗ.
Then order passed at Annexure D by respondent number 1. City Corporation. What is Annexure A?
Lord, it is a communication issued by the corporation that they want approval from the government to issue proper conveyance.
So government consider ಮಾಡಬೇಕಾ?
Earlier also there was an
Corporation
order.
needs permission from the government.
Urban Development Department.
Yes, my lord.
Urban Development or Revenue na?
Urban development.
Urban development.
ನೀವು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಪ್ಪ?
Corporation.
ಗವರ್ಮೆಂಟ್ ಕೊಡಬೇಕು.
ನಾನು ಏನು
The petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that despite the order dated 19/1/2007 passed by respondent number 1, City Corporation Belgavi at Annexure D, the sale deed has not been executed. A deed of conveyance has not been executed in favor of the petitioner. Learned counsel appearing for respondent number 1 would submit that vide letter dated 14/11/2018 produced at Annexure A, the corporation has informed that the corporation is awaiting necessary permission and sanction from the Urban Development Department. If that be so, ನೀವು ಕಳಿಸಿದ್ದೀರಾ Urban Development Departmentಗೆ?
ಇದು
It is sent
It is sent to Chandrakala Moite
to
Jadhav
the
ಅಂತ
party.
party
It is
ಅಂತ.
party.
It is addressed to the party itself, my lord, by the corporation. They have to challenge.
Challenge alla. You are waiting permission anta. In that view of the matter, the representation submitted at Annexure D to the corporation would not serve any purpose, reserving liberty to the petitioner to submit necessary representation to respond number 3 for grant of such permission and or sanction. The petition is disposed, directing respond number 3 to consider the representation of the petitioner as and when filed within a period of 30 days thereafter in accordance with law.
After considering only, it is intimated that ಸರ್ಕಾರದ ಅನುಮೋದನೆ ಪಡೆಯಬೇಕಾಗಿರುವುದರಿಂದ because the lease
ಅದಕ್ಕೆ
has to be-
ಸರ್ಕಾರ ಕೇಳಿದೀವಿ ಅನುಮೋದನೆ ಮಾಡಿ ಅಂತ.
ಅವ್ರು ನಮಗೆ ಕೇಳಿಲ್ಲ, ಅವ್ರಿಗೆ ಅವ್ರು ಕಮ್ಯುನಿಕೇಶನ್ ಮಾಡಿದ್ದಾರೆ, ಬಟ್
ನೀವು ಕೇಳಿಲ್ವಾ?
ಇಲ್ಲ ಕಳಿಸಿದೀವಿ ಅಂತ ಹೇಳಿದ್ರೆ
ಇವರೇ ಕೇಳಿದ್ ಕಾರ್ಪೊರೇಷನ್ ಸರ್ಕಾರನ್ ಕೇಳಿದ್ annexure A
ಸರ್ಕಾರಕ್ಕೆ ಬರ್ದಿದ್ದೀರಾ ಮಿಸ್ಟರ್ ಕೌಜಲ್ಗಿ?
ಬರ್ದಿದ್ದಾರೆ.
Pardon, my lords?
ಸರ್ಕಾರಕ್ಕೆ ಬರ್ದಿದ್ದೀರಾ?
ಹೌದು, that is what is reflected in page number 12.
13.
Page number 13 rida 12 page number 12 my lords. ಆದ ಪ್ರಯುಕ್ತ KMC ಕಾಯ್ದೆ 1976 section 267 read with section 266 ಮತ್ತು section 176 ಅನ್ವಯ ರಸ್ತೆ ಅಗಲೀಕರಣದಲ್ಲಿ ಜಾಗ ಕಳೆದುಕೊಂಡವರಿಗೆ ಪರ್ಯಾಯವಾಗಿ ಲೀಸ್ ಆಧಾರದ
ನೀವು ಬರ್ದಿದ್ದೀರಾ ಗವರ್ಮೆಂಟ್ಗೆ?
ಇದು
ಇವ್ರಿಗೆ ಹೇಳಿದ್ದೀರಾ ಗವರ್ಮೆಂಟ್ ಪರ್ಮಿಷನ್ ಬೇಕು ಅಂತ?
ಅದು that I have to take
ಯಾರು ಕೇಳ್ಬೇಕು ಪರ್ಮಿಷನ್?
Pardon, my lords?
ಅವ್ರು ಕೇಳ್ಬೇಕಾ ಪರ್ಮಿಷನ್? ನೀವು ಕೇಳ್ಬೇಕು?
ನಾವು ಕೇಳ್ಬೇಕು.
ನೀವು ಬರ್ದಿದ್ದೀರಾ?
Page number 13 ಒಳಗೆ
ಅದನ್ನ I have to take instruction regarding that.
Anyway, we have asked them to submit the representation.
Lord, the application seeking conversion, my lord, from residential to commercial has been, Lord, rejected by virtue of impugned endorsement on the ground that in the earlier occasion, this honorable court, my lord, has held that, my lord, the land cannot be converted from residential to commercial purpose.
Get instruction.
On the premise, my lord.
Land AGA accepts notice for respond number 1 to 5. 6 ಯಾರು?
6, Lord, I have to assert 6.
ಕುಸುಗಲ್ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಕುಸುಗಲ್ ಹುಬ್ಬಳ್ಳಿ ತಾಲೂಕು PDO. ನೆಕ್ಸ್ಟ್ ಕೌನ್ಸಿಲ್ ಹೇಳಲಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬಿಡೋದು. Counsel for the petitioner is unable to give the name of the counsel, standing counsel for respond number 6 is dismissed. Issue notice to respond number 6 returnable by 20th March.
I'm Athini for petitioner, my lordship,
Mr. Atti,
seeking mandamus.
where's Mr. Atti? Allotment of site. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the application submitted by the petitioner for allotment of a site in the APMC yard Saundatti and the representation issued in relation thereto dated 14/12/2023 have not been considered. Whenever any application and or representation is submitted, it is for the respondent authorities to consider the same and either accept or reject within a reasonable period of time. Needless to say, if it is rejected, by giving appropriate reasons. Neither having been done, I pass the following order. Writ petitions allowed, a mandamus is issued directing respondent number 3 and 4 to consider the application dated 2/7/2018 at Annexure D and the representation dated 14/12/2023 at Annexure G within a period of 30 days from the date of receipt of a copy of this order in accordance with law.
Defendant's petition, my lordship. Defendant's petition challenging the amendment, my lordship.
Suit for?
Suit for partition.
Yes. What is the application? 6 Rule 17.
Please, my lordship. Plaintiff had filed an application, my lordship.
Stage, you know?
Now it is for the evidence, my lordship. After commencement of defendant number 1 evidence, defendant evidence, this application came to be filed, my lordship. My
Where is the
lordship.
amendment application?
It is at amended, proposed amendment is at page number 40, my lordship.
40.
Lordship,
No relief has been sought for, only
no, page number 23, I may be permitted to draw the kind attention of
relief
this.
ಏನು ಕೇಳಿಲ್ಲ.
Relief not sought, my lordship.
ಬರೀ
He's
amendment.
withdrawing the admission. That's what, that is what page number 23, my lordship, in the plaint,
Yes.
para number 4. May I permitted to read out, my lordship. Here in this para number 4, he says that there was a partition effected by the father, propositor Shivmurtaya, and the suit property is allotted to father himself. Now here he says that it is separate property of father. In the amendment, he withdraws the same.
Is withdrawn and is not seeking for any relief as
Relief.
regards the will and the compromise decree. Issue notice to the respondents returnable by 9th April. The further proceedings in OS number 21 of 2022, pending on the file of the Principal Senior Civil Judge and JMFC Jamkhandi, he stayed till the next date of hearing. Process fee and copies to be furnished by end of day 17th February. Acknowledgement for service of notice on the respective counsel for respondent to be filed on or before 21st February, failing either of which, the interim order will stand automatically vacated.
Grateful, my lordship.
7, Impleading.
Yes.
My lord, in this case, plaintiff is a tenant, my lord. He taking the advantage of dispute between defendants, ownership between the defendants, he is not paying the rent, my lord. He has filed the suit for permanent injunction, falsely claiming that we are restraining him and evicting him from the property, my lords. We have filed the application seeking for the deposit of rent, monthly rent to court, my lords, which was rejected. The ownership is disputed, my lords, but we are.
Deposit in court.
Yes.
Alva.
Yes. Please.
Issue notice to the respondents returnable by 9th April. The further proceedings in OS number 156 of 2018, pending on the file of the Principal Civil Judge and JMFC Ranebenur, he stayed till the next date of hearing. Process fees and copies by 17th, acknowledgement by 21st. A peril of the impugned order indicates that the same is not in compliance with the circular dated so and so. Additional Registrar Judicial is directed forward a copy of the circular dated so and so to the Principal Civil Judge and JMFC Ranebenur, so that the same can be followed in future in all the orders passed.
Much.
Right. These prisoners are the defendants, Maharaj, in a suit filed by the plaintiff respondent for injunction, Maharaj. They have filed an application about the appointment commissioner 26 rule 9. Because there is a road in the land of this defendant, the plaintiff, Maharaj. It has been there since many years. So on the two grounds, the learned judge has dismissed. One, it amounts collection, the other is not it is premature stage. So this collection evidence is not a local inspection will help the court to decide the matter.
Do you want to know whether the road exists or not? How is that relevant?
Hello?
How is the existence of the road relevant in a suit for injunction?
Well, he is saying that we are disturbing his possession because there is a road in our contention. There is a road and there is another suit is.
You are using the public
yes,
road.
Well, yes.
And not his property.
Yes, that is the road. He said that it belongs to his part. There is a separate suit, Maharaj, that. So.
Issue notice to the respondent returnable by 9th April. The further proceedings in OS number so and so pending before so and so is stayed till the next date of hearings. Process fee by 17th, 21st. Yes.
Matter pertaining under Land Reforms Act. Petitioners are the tenants, my lords. Kindly take annexure B, my lords. Page 31. B for boy.
Page?
31.
Yes.
Two lands are there. Sada code, it's an ordinary tenant. Translation is on the next page, my lords. Adiyappa and Shivram, they are tenants as 1/6 crop share basis. This entry is way back in 1959.
Hmm.
My lord, next page is, my lord, the annexure C is, my lord, the RTC extract from 1965 to 82, my lords. All throughout, my lord, the name of tenants are entered. Method of cultivation is 4. 4 denotes crop share.
1968 to
65,
73,
66 to 81,
74.
82. And thereafter also same position continues even now.
Hmm.
My lord, next item, next land, my lords, page number 39.
Hmm.
This land is, my lords, on the basis of Kablayat at the agreeing to pay rent of rupees 50 per annum. My lord, this is also from 1960.
Hmm.
Entries, my lords, their consequent entries or RTCs are produced for the same years. Method of cultivation is 3, denoting, my lord, the tenancy basis.
Yes.
Tribunal, my lords, rejects the application on 3 grounds.
Hmm.
One, kindly take impugned order. Page 29 is the findings part.
Hmm.
One is the tenants have not produced any material to show that they are tenants. Turning a blind eye to the, my lord, the entries and also, my lord, the mutations. Second is that one of the son of this original tenant, now the 2 generations have passed.
Hmm.
My lord, he was serving as FDA in local office.
And AGA accepts notice for respond number 1 and 2, issue notice to respond number 3 to 13.
My lords, one of them has entered caveat. Number 12 has entered caveat. My lords.
Shivkumar Aparaj.
Yes, he's from here only. I served a copy on him.
High Court appear ಆಗ್ತಾರೆ.
Serve ಮಾಡಿದ್ದೀನಿ.
Issue notice to respond. None appears for the caveat.
He appears with the Bangi, my lords. He's Bangi's colleague. Mr. Bangi's colleague.
Nobody is here.
ತಗೊಂಡ್ರೆ ತಗೋತೇನೆ.
I think none appears ಅಷ್ಟೇ.
Makes no difference for me. When I am taking for 10 persons, another person makes
None appears for caveat respond number 12. Issue notice. Learned AGA accepts notice for respond number 1 and 2. Issue notice to respond number 3 to 11 and 13. Returnable by 15th April. The operation of
impugned order annexure A, my lords.
the order dated 29/8/24 passed in case number so and so by respond number 1 at annexure A is stayed till the next date of hearing. Both the petitioner and respond number 3 are directed not to in any manner put up any construction, deal with
Agricultural and
the
status quo regarding positions.
status quo, not to put up any construction, not as also not to deal with, alienate or encumber
Yes.
the property subject matter of the aforesaid
Writ petition.
case number TNC stroke SR-1512 plus 940 till the next date of hearing. Process fee and copies to be furnished by end of day 17th, failing which the interim order will stand automatically vacated.
Plus time furnished copies by
17th, Monday.
Monday. Could it be Tuesday? Not 10 persons are there. ಒಂದೊಂದು ದಿವಸ ಜಾಸ್ತಿ.
Tuesday.
Oblige.
Sorry for the interruption. In my matter, interim order not sought, my lord. Therefore,
Interim order not sought for.
not sought, my lord. Sorry, my lord. That's why I have noticed this now. So I'm bringing it. lord.
ಬೇಡವಾ?
Like sought for my lord. ಅದಕ್ಕೆ ಕೊಟ್ಟಿದೆ. ಅದಕ್ಕೆ without their prayer, ಅದಕ್ಕೆ it should not be.
Prayer ಕೇಳಿಲ್ವಾ?
ಇಲ್ಲ my lord. ಅದಕ್ಕೆ it should not be.
ಬರೀ notice.
Yes, ಅಲ್ಲ, ಅದಕ್ಕೆ as not sought. Therefore,
What do you want to do? You want to file an application?
Yes, my lord. I want to file a
Pass over.
Yes, my lord.
Yes.
This is a construction by respond, my lord, building without seeking permission. In spite of my petitions to the corporation, they issued notice to him.
Hmm.
And he did not respond. Even they issued notice under 321 also. But he is going on constructing without obtaining permission from the corporation.
321 ಆಗಿದೆ.
ಆಗಿದೆ sir, your lordship.
3 ಆಗಿಲ್ಲ.
3 ಆಗಿಲ್ಲ, ಮಾಡ್ತಾ ಇಲ್ಲ ಅವ್ರು. They specifically say there is no permission.
Where the 321 one?
321 one is at page number. 3 is also there. 312/6/2020 and annexure N, page 84. Page 84.
84.
Annexure N.
321-1.
ಅಲ್ಲ, three,
3
One.
ಎಲ್ಲಿದೆ?
this is the 3, my lord. Page 84 is ಪ್ರಕಾರ ಕ್ರಮ ಜರುಗಿಸಲಾಗುವುದು.
ಸೊ ಇನ್ನ ಕ್ರಮ ಮಾಡಿಲ್ಲ.
ಮಾಡ್ತಾನೆ ಇಲ್ಲ.
ಫೈನಲ್ ಆರ್ಡರ್ ಮಾಡಿಲ್ಲ.
ಮಾಡಿದ್ದಾರೆ. That order is at page number 87.
87.
ಪಾಲಿಕೆಯಿಂದ ಸದರಿ ಜಾಗೆಯಲ್ಲಿ ಪರವಾನಗಿ ಪಡೆಯದೆ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಮಾಡಿದ್ದರಿಂದ ಸೂಕ್ತ ಕಾನೂನು ಕ್ರಮ ಜರುಗಿಸಿ ಕೆಎಂಸಿ ಕಾಯ್ದೆ 74 ಕಟ್ಟಡ ನೀಡುವಂತೆ ಆದೇಶಿಸಲಾಗಿದೆ. This is on 9/10/2024. Thereafter also he is going on constructing one after the other floor.
Shri Gurudev Gachanmat is directed to accept notice.
Kabur is also there.
IK Kalburgi is directed to accept notice for respond number 1 and 2. Issue emergent notice to respond number 3, returnable by 15th April. Notices have been issued under section 321(1) and 321(2) of the Karnataka Municipal Corporation Act 1976. The contention of counsel for the petitioner is that respond number 3 is proceeding with the construction. In that view of the matter, respond number 1 and 2 are directed to ensure that there is no further construction which takes place in the said property until necessary orders are passed under subsection 3 of section 321. The respond number 1 and 2 would also have to issue necessary instructions to the ESCOM and the water
board.
Water you were there. Nivena?
No. Karnataka Urban Water Supply.
Karnataka Urban Water Supply Board not to issue any water connection to the subject property, as also to ensure that there is no occupation made of the subject property till the culmination of the proceedings.
Yes.
Process fee and copies to be furnished by end of day 17th February, failing with the interim order will stand automatically vacated.
Much obliged.
Mr. Kalburgi, respond number 1 and 2, counsel for respond number 1 and 2 is also directed to place on record the officers in charge of the ward during time the construction has been put up and why no action has been taken by the said officers as regards the illegal construction.
Please.
The petitioners are challenging, my lords, the improved survey orders done by the respondent number 3 to 5 and my lords, that order passed by the respondent number 1 and 2. My lords, by dismissing our my lords, appeal and revision. My lords, the main contentions, my lords.
You are
that
challenging the order of 2022.
No,
And
it's a
AG
24
accepts-
order. 24 order.
Confirmed in 24.
Yes, confirmed in 24, but I got an interim order during pendency of the my lords that
Original order
appeal
is
before.
22. And AG accepts notice for respond number 1 to 5. Issue emergent notice to respond number 6 and 7, returnable by 12th March.
Lords, challenging the interim order.
You are asking for 24 to be stayed, 22 only there. You
Illa.
are not asked for 22.
24 order that which has confirmed, my lords, in the revision petition, my my lords,
Correct.
petition
So
was
should you not
dismissed.
challenge 2022?
22 also I challenge.
Where have you challenged? Interim prayer?
My lords, annex, no, interim prayer as madilla.
What is the point in,
No, all for
what is the point in
proceedings.
staying 24 order?
I'll make my lords
Anyway,
necessary.
we can't stay 22
Alla,
order
alla,
now.
I will make necessary corrections.
Make
my lords,
necessary
till
correction,
then.
interim order we can't give.
Alla, interim order make and be granted. I'll make necessary corrections now itself, if I am permitted. my
Correction
lords.
ಮಾಡಕ್ಕಾಗಲ್ಲ, amendment application ಹಾಕ್ಬೇಕು.
Alla, I'll file amendment application,
File ಮಾಡಿ.
but subsequent to this, my lords, what has happened is, illa,
Permissive, it said
But
2022
I know, my
order,
lords.
we are not going to stay it. Let the service happen. You want to take hand summons, you take hand summons. Counsel for the petitioner is also permitted to take hand summons on respond number 5 and 6.
lords make and fix a short date, my lords, I will.
And move the court after service.
I can status quo at least, my lords, because now
Not a
they are
22 order.
they are interfering with the possession, my lords, now.
Yes.
Notes the petition is filed by the petitioner challenging the order dated 23/7/2024 at Annexure J. Notes in this, notes the property CTS survey number 624, 625, 114, 633B. They belong to the testator, Milords, that is Karabasappa Madevappa Hubli. In 2010, Milords, the original testator, he registered a will deed, Milords, in the favor of the petitioners.
Yes.
There was before that, Milords, there was earlier there was a will in 2000.
Where is the will?
Milords have produced the worthy, Milords, at Annexure B, Milords.
Where is the will?
Will is at, Milords, page number 37, Milords.
37. ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದರಲ್ಲಿ?
In the favor of the petitioners, Milords. Petitioner, current petitioner. It's on page number 37, Milords. May see Shivayogappa, Ravindra, Amrut, 3 petitioners, Milords.
Yes.
In the name of Milords. Thereafter, Milords, there was a prior will, Milords, which came to be cancelled on the same date this will was registered. The earlier, the beneficiaries of the earlier will, Milords, they got their name entered, Milords, in the mutation entries in the year 2018.
Now you want their name to be deleted and you
Milords, now it is deleted, Milords. Now it is deleted.
Milords. You not made them parties.
No, now their name is already deleted, Milords.
You have to make them
deleted.
Parties.
Milords, now I gave a representation to register, enter my names according to the registered will, to which, Milords, the respondent, respondent number 2, he has asked me to secure probate, Milords, from a civil court.
If there is a dispute,
there is no dispute, Milords. With regards to this will, there is no dispute.
You are not even making them a party. You want to make them a party or no?
Milords, earlier proceedings they were.
You want to make them a party or no?
So, I'll make them a party, Milords.
Counsel for the petitioner seeks for and is granted 2 weeks' time to file necessary application to implead the legatees under the earlier will of Karabasappa. Relist on.
Milords, still then, Milords, interim order may be given, Milords.
Yenanta?
Not to alter the entries, Milords.
You are not making them a party. How can we pass such an order?
Milords, they fought it before the respondent, Milords, and it was rejected, Milords. Their will was rejected.
They are not granting you any interim order. Firstly, you are trying to file a petition without making them a party to get an order behind their back. We won't encourage all that. When will you file the application?
File it next week, Milords.
And until they are served, no order will be passed.
Please, Milords, I'll file an application next week itself. Next week, any date may be given.
List on 20th February.
Much appreciated.
Yes.
Instead of Sunil Desai, the name of Hanumanth Reddy Saukar may kindly be shown, and I have already served the copy on him. He is representing respondent.
Submitted that Shri Hanumanth Reddy Saukar is the standing counsel for the respondent and not Mr. Sunil S. Desai. Hence, registry is directed to print the name of Shri Hanumanth Reddy Saukar as that appearing for the respondent, delete the name of Shri Sunil S. Desai as that appearing for the respondent. Counsel for the petition served 2 sets of the petition along with annexures.
No, I already served the copy to him.
On the said counsel, if
Yes.
not already served. Illi avrelli.
He is there, my lordship. He has come. Kindly prosper. Since, my lordship, the respondent authorities have issued license in the month of October 2024.
Pass over, call him.
Please.
Please note. Lord, the order of the Deputy Commissioner reserving a major portion of a betta or hardy land for non-forest purpose is challenged in this petition. My Lord, this issue is squarely covered by the judgment of the coordinate bench, which is produced at Annexure F, my Lord. In page 39, it starts, Annexure F. Relevant paras would be para 5 to 9, my Lord. My Lord, the issue for consideration was, in view of the section 2 of the Forest Conservation Act 1980, without the approval of the consent of the central government, forest land cannot be used for non-forest purpose. And this assigning the hardy land or betta land or kumki land for non-forest purpose under section 71 of the Karnataka Land Revenue Act is only permissible if it is a unoccupied land.
So now what is the purpose for which they want to use it?
They want to construct houses in 9 acre 37 guntas.
ರೋಡ್ ಮಾಡಿ ಅಂದ್ರೆ ಆಗಲ್ಲ ಅಂತೀರ. ಇವಾಗ ಮನೆಗಳು ಕಟ್ಟಕ್ ರೆಡಿ.
My lord, as per annexure E, my lord, the same deputy commissioner.
I don't have access 3 feet ಇದೆ ಒಂದು 10 feet ಮಾಡ್ಕೊಡಿ ಅಂದ್ರೆ ಇಲ್ಲ. Forest land.
My lord, the same deputy commissioner.
ಕಲ್ಸೂರ್ ಮಟ್ಗೆ ಕೊಡ್ಬೇಕು notice to respond to both of them together. Let us see what argument you advance on both.
My lord, same deputy commissioner as per annexure.
Accepts notice for respond number 1 to 4. 5 ಯಾರು?
5 municipality, Bhatkal.
Standing council ಯಾರಪ್ಪ?
SVH. ಗೊತ್ತಿರಲಿಲ್ಲ.
Next time ಬಂದಾಗ you should be able to tell us who the standing council in for each of them are. SVIG for respond number 5. 6 ಯಾರು?
6 Karnataka Slum Development Board, my lord.
ಅದು ಗೊತ್ತು. ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಯಾರು?
Not aware, my lord.
ಸ್ಲಮ್ ಡೆವಲಪ್ಮೆಂಟ್ ಬೋರ್ಡ್ ಯಾರು?
Slum Development.
ಬೆಳಗಾವಿ, ಧಾರವಾಡ.
Bangalore.
ಇಲ್ಲಿ ಯಾರು? ಬೆಂಗಳೂರು ಆದ್ರೆ ಏನಂತ ಸ್ಲಮ್ ಡೆವಲಪ್ಮೆಂಟ್ ಬೋರ್ಡ್ ಒಂದೇ.
Slum boarding mostly.
Notice.
Dayanand Bandi water slum. Dayanand Bandi. Slum board. Water board. Raviraj Patil appears slum boarding.
Shri Raviraj Patil is directed to accept notice for respond number 6. In the event of Shri Raviraj Patil not being the standing council,
Yes.
petitioner is permitted to serve any other standing council for respond number 6.
Please.
The operation of the order passed by respond number 2 bearing number so and so dated 15/3/2024 at annexure D is stayed till the next date of hearing. The respondents are called upon to make the submission as to how a forest land is now proposed to be utilized for construction of houses by de-reserving such forest land, more so in view of section 2 of the Forest Conservation Act.
Please.
Released on 12th March.
Please.
Make request.
14th March.
Serial number 11, madam.
4. Okay. Yeah.
Serial number 11, my lords. File necessary application for amendment, then afterwards I will move the matter.
We are not going to stay it. We are not going to stay at 22 order. We have told you that.
No, but I have not sought for, my lords, interim order. Therefore, my lords, I have not sought for interim order of that. For that reason.
11. Shri B. Sharon Basava submit that you would be filing an application to challenge the order of 22. And as such, the same may be stayed. An order having been passed in the year 2022 cannot be stayed now. Hence, his request is rejected.
No. ಇಲ್ಲ
ಹೇಳಿದ್ರೆ ಕೇಳಲ್ಲ ಅಂತೀರ.
ಇಲ್ಲ ಬೇಡ ಸುಮಾರು at observation.
Darigaon. Pass over.
Lord, the petitioner filed this Lord petition challenging the Lord seeking the mandamus Lord against respond number 3 and 4 Lord. The admission of them Lord, the petitioner was secured Lord on 9/10/2020 Lord, and partly he has paid them Lord 25,000 towards fees Lord. Thereafter Lord, as per annexure A Lord, he has paid the another 25,000 on 9/12/2020. At the moment of the Lord, the examination Lord, his admission is cancelled Lord. That is annexure C, my lord. On the ground that, my lord, he is across the 35 years age, my lord. And it is mentioned as, my lord, 11/11/1986, my lord. Annexure C, my lord, date of birth, my lord. Therefore, my lord, the petitioner submitted the representation, several representation. However, it's not considered.
Nimde birth date,
1984, my lord.
ಇನ್ನ ವರ್ಷ ಆಯ್ತಲ್ಲ.
No, my lord, on 9/10/2020, my lord. It was 35 years was running, my lord. Not across the 35 years, my lord.
ಕಟ್ ಆಫ್ ಡೇಟ್ ಏನು?
35 ಇದೆ, my lord.
ಅಲ್ಲ, ಕಟ್ ಆಫ್ ಡೇಟ್ ಏನು? ವೆನ್ ವಾಸ್ ದಿ ಅಡ್ಮಿಷನ್ ಫಾರ್ ವಿಚ್ ಇಯರ್? ಅದಕ್ಕೆ ಕಟ್ ಆಫ್ ಡೇಟ್ ಏನು?
Minimum age of the admission will be 17 years. And
Minimum ಆಯ್ತು.
as on 31st December of the year, my lord. Page number 8, my lord.
Yes.
Fifth
Age limit is 35 years for ANM. ANM for LHV ಅಂದ್ರೆ?
ANM means
Who is the counsel for respond number 1?
it is a government, my lord. It is a state
Dhaka Nursing and Paramedical Board.
board, my lord.
Regulatory authority.
1, 2 and
State.
state.
And AG accepts notice for respond number 1, 2 and 4.
Please.
Issue notice to respond number 3. Emergent notice to respond number 3. Returnable by 3rd March. Counsel for
Please.
the petitioner is also permitted to take out hand summons.
Please.
Respond number 3.
Please, much or less.
Copy code. The petitioner for direction to consider the application filed by the petitioner at Annexure B to conduct a survey, Lordship. He has filed application on 18/12/2024, my lord.
Online application ಹಾಕಿದ್ದೀರಾ?
Please.
ಎಲ್ಲಿದೆ online application?
Annexure B, Lord. Page number. Page number 7.
Online application ಇದೆ. And AGA accepts notice for respond number 1 and 2. The submission, the grievance of the petitioner is before this court seeking for the following. The grievance of the petitioner is that the online application submitted by the petitioner for Fodi and Durasti on 18/12/2024 is still not considered and no action has been taken. When an application is submitted by a citizen to an authority, the said authority is required to act on the same within a reasonable time frame, more particularly as per the Sakala so-and-so Act. The application having been submitted on 18/12/2024, no action having been taken, I pass the following order. Writ petition is allowed. A mandamus is issued directing the respondents to consider the online application dated 18/12/2024 of the petitioner and act on the same by issuing notice to all the stakeholders of the land in survey number 32 of ಯಾವ village appa? Amlikoppa, Dharwad.
Dharwad Taluk.
Carry out a survey, demarcate the extent of land of all the stakeholders and thereafter issue necessary orders. They are about to be completed within a period of 6 months from the date of receipt of a copy of this order.
18
Beneficiaries writ petition are challenging the award passed before the Lok Adalat. But here, my lord, the approval was not given for compromise. But the compromise is attained, my lord, and it is recorded.
By whom?
Lordship sees Annexure F. The parties have not signed the compromise petition at page number 53, my lords. Only councils have signed there's some discrepancies. My lord, 2009, my lord, there was order in a miscellaneous petition to refer to the court. It was, my lord, endorsement was issued that there is no tally for the survey numbers and the extent. But after that, my lord, in 2017, my lord, this petition, this is forwarded. In compromise petition, my lord, it has been disposed of.
What action have you taken against this lawyer?
No actions.
Why? The lawyer has signed on your behalf and filed it. And he is the government pleader.
government pleader for SLO, or for beneficiary, there's another advocate. Both SLO and executive engineer,
Hmm.
they have not signed.
What action have you taken?
No action is taken.
ನೀವೆಲ್ಲ ಏನು ಆಕ್ಷನ್ ತಗೊಂಡು ಆಮೇಲೆ ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು SLO ಡಿಡ್ ದಿಸ್, ಲಾಯರ್ ಡಿಡ್ ದಟ್, ಕೇಸ್ ಆಫೀಸರ್ ಡಿಡ್ ದಟ್ ಅಂತ ಬಂದ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಹೇಳ್ತೀರಾ. ಯು ಡೋಂಟ್ ಟೇಕ್ ಎನಿ ಆಕ್ಷನ್ ಅಗೇನ್ಸ್ಟ್ ದೆಮ್. And that SLO continues to be sitting in your office, against whom you make all these allegations.
Action is not taken, my lord.
Why? Then we can't accept it if you don't take any action. You will continue to have the said lawyer.
Yes, ma'am.
And the claimant is settle ಆಯ್ತು ಅಂತ ಹೋಗಿರ್ತಾನೆ, ಆಮೇಲೆ ಇಲ್ಲಿ ಬಂದು ಹೇಳೋದು. The settlement of when?
10/6/2017.
And you are coming after 8 years.
Yes, an execution is filed. That's what. Now execution is filed.
When?
Execution in the year 2022, my lords.
Attachment warrant ಆದಾಗ ಬರೋದು. ಅದು 14/7/23 ಇಂದ you have been avoiding attachment for 1.5 years.
But I sought for the documents. There's some delay in filing because of these documents, this correspondence, my lord.
The contention of learned counsel for the petitioner is that a compromise has been entered into before the Lok Adalat without the authorization on part of the petitioner. By referring to the joint compromise petition filed before the Lok Adalat, it is contended that the respondent SLO as also the beneficiary petitioner have not signed the said compromise petition. The same has been signed only by the additional government pleader on their behalf. And as such, the compromise petition is not binding on the petitioner. On inquiry as to whether any action has been taken against the additional government pleader for having signed the same without signed the compromise without the authorization of the petitioner, learned counsel for the petitioner submits that no action has been taken. If that be so, then the submission of the counsel for the petition cannot be accepted 8 years after the compromise has been recorded.
Give it to lordship. In 2 to 3 matters, this has happened. In other matters also.
You have to take action against them.
I understand.
Nobody knows in your KNL what is happening. ಯಾರಿಗೆ ದುಡ್ಡು ಕೊಡಬೇಕೋ ಕೊಟ್ಬಿಡ್ತೀರಾ, ಯಾರಿಗೆ ಬೇಡೋ ಕೊಡಲ್ಲ. We can make a further statement which we are not making. Everything is wrong in your KNL. You have to close down this KNL. The whole purpose is lost. From the time they have entered the picture, everything has become a chaotic farce.
Lordship sees annexure C, my lord. When miscellaneous petition was allowed, it was not forwarded at page number 47, lordship.
Forwarded by whom?
My lord, miscellaneous petition was filed, my lord, because the reference was not sent to the court. For that, my lord, again in Lok Adalat, there was an order to send the reference to the court. That annexure C, your lordship may kindly see. 2009, my lord, endorsement was issued.
This is signed by the SLO.
Yes, yes. But that time it was refused, 2009.
Lordship, may I read that, ma'am? ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹಿರೇಕೆರೆ ತಾಲೂಕು ಮೈದೂರು ಹಾಗೂ ಗುಡ್ಡದ ಮಾದಾಪುರ ಗ್ರಾಮದ ಹಲವು ಜಮೀನುಗಳಿಗೆ ತುಂಗಾ ಮೇಲ್ದಂಡ ನಿಯೋಜನೆ ಕಾಲುವೆ ನಿರ್ಮಾಣಕ್ಕಾಗಿ ಭೂ ಸ್ವಾಧೀನವಾಗಿದ್ದು ಕ್ಷೇತ್ರ ಹೆಚ್ಚಿನ ಪರಿಹಾರ ಧನವನ್ನು ಕಲಂ 18(1) ಕೆಳಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು ಸದರಿ ಅರ್ಜಿಗಳ ಅವಧಿ ಮೀರಿರುವುದರಿಂದ ಸಂಬಂಧಿಸಿದ ವಕೀಲರಿಗೆ ಹಿಂಬರವನ್ನು ನೀಡಲಾಗಿತ್ತು. ಮೇಲ್ಕಂಡ ಉಲ್ಲೇಖ 1ರ ತಮ್ಮ ಪತ್ರದ ಪ್ರಕಾರ ಸದರಿ ನಿವೇದನಾ ಅರ್ಜಿ ಹಾಗೂ ಸಂಬಂಧಿಸಿದ ಕಾಗದ ಪತ್ರಗಳನ್ನು ಕಳುಹಿಸಿದೆ. My Lordship, see the serial number 5. This is the, my Lord, claimant here. It says ಹೆಸರು ಸರ್ವೆ ನಂಬರ್ ಹಾಗೂ ಕ್ಷೇತ್ರ ಹೊಂದಾಣಿಕೆ ಇಲ್ಲಿದ್ದರಿಂದ ಪ್ರಕರಣ ಕಳುಹಿಸಲಿಕ್ಕೆ ಬರಲಾರದು.
To enable the counsel for the petitioner to place on record the action taken against the additional government pleader who had signed the compromise petition at Annexure F, released on 24th February. To take action and come, then we'll consider it.
Even KNNL council has also signed. Even for the
Take action and come.
Only the Lordship said only against the government advocate.
Additional government advocate and the counsel for the petitioner. Yes.
Lords, writ petition challenging orders passed by respondents 1 and 2, my lords. That is the deputy commissioner and assistant commissioner.
You're the purchaser or you're the?
I'm the purchaser, my lords. In fact, I'm the 6th purchaser, my lords. The first transaction at
And AGA accepts notice for respond number 1 and 2. Issue notice to respond number 3 to 10. AGA for 1, 2 and 11. Issue notice to respond number 3 to 10. Returnable by 15th April. The operation of interim order ಏನು ಕೇಳಿಲ್ಲ.
Page number 15, my lords. Annexure E and Annexure H.
The operation of Annexure E and H is stayed till the next date of hearing. Both the petitioners and respond number 3 to 10 are restrained from putting up any construction on the subject property and or dealing with alienating, encumbering the subject property till the next date of hearing. Causes fee and copies to be furnished by end of day 17th February, failing which the interim order will stand automatically vacated.
Obliged.
IA 1 of 25 is allowed, production of Annexure E is dispensed with.
In this case, my lord,
Yes.
the annexure K, my lord, and L, which is dispensation which we have sought. This is, my lord, recommendation made for disqualification of the petitioner. This is challenged, and subsequent to that, the first respondent has issued notice. Kindly see that the petitioner, my lord, is a member of Vajrali Gram Panchayat, Yellapur Taluk, my lord. And
regional commissioner has passed the order.
A regional commissioner has passed.
You have appellate remedy.
Lord, it is only a recommendation. He has not
This
passed
is
an order.
recommendation, my lord. I'll draw your lordship's attention. Since, my lord, the petitioner
Impugned order ಅಂದಿದ್ದೀರಾ? This is
recommendation for disqualification.
It is a recommendation.
For
Can you challenge a recommendation?
I'll draw your lordship's attention. Similar this honorable court considered. Apart from that, division bench has hold.
That a recommendation can be quashed.
Yes, yes.
Kodi?
This is, my lord, a recommendation. This court has passed order. Another, my lord, insofar as recommendation is concerned, this honorable court has passed order. The writ petition is maintainable. Kindly, Kodi, sir. Kodi, sir. I'll draw your lordship certain peculiar circumstances of the case. Here, my lord, that 43A is not
a final order. This is an interim order.
Interim order. I'm asking interim order, but my lord, in this
We are
case,
asking you on maintainability.
maintainability only this honorable court 226 is maintainable.
Yes.
Kindly see, my lord. Here, my short point for consideration is this. I am elected member for the year of 2010 to 15 and 15 to 16 to 21, 20, my lord. Thereafter, third time that I have elected.
You show us.
Kindly see.
What is the
The
section 43?
43A.
43A.
Ram Swaraj
Kindly
Panchayat.
come to para 8 of this judgment.
Let us see first 43.
ಇದರಲ್ಲಿ ಬಹಳ ಚೆನ್ನಾಗಿ ಬರೆದಿದ್ದಾರೆ ಸರ್. And Lordship Vinith Kotari also has passed order. And para 8 has dealt. That is, my lord, 43A subclause 4 of subsection 1 of 43A. That is, my lord, the 43A subclause 1, subclause 4. In that, my lord, any contract which is given to the relatives, then, my lord, kindly see, in execution of any work, panchayat contract or otherwise found involved directly with any person
No
who
para
is
8 in this judgment. There's only para 7.
para 8, yes.
Para 8 illa.
Para 8 ಇಲ್ಲ ಅಂತಾರೆ ಅಲ್ಲಿ.
Para 8 ilva.
Illa.
ಇದು ಕೊಡಿ.
7 is the last para in this judgment. ಯಾವ judgment ಕೊಟ್ಟಿದ್ದೀರಾ? ILR
2003 Karnataka 3035.
There is no para 8.
ಇದೇ ಕೊಟ್ಬಿಡ್ತೀನಿ. ಅದು ಕೊಡಿ. Para 8.
How can you have a different judgment?
ಅದು ಕೊಡಿ ಅದು ಒಂಚೂರು.
ಇದರಲ್ಲೂ para 8 ಎಲ್ಲಿದೆಯಪ್ಪ? Para 7 is the last para.
Para 7 last para.
ಒಂದು ನಿಮಿಷ. Para 6, sorry. Starts from para 6. Guess fact. ತಂದಿದ್ದೀನಿ ಹಾಕೊಂಡು.
Yes.
As far as main issue is concerned, we have carefully applied our minds to the provisions of section 43A. It is true that this section empowers government, and that too for good reasons, to inquire into different heads of sheets of misconduct committed by elected representatives of, if it is result of the inquiry in adverse which disqualified the candidate to remove the person from the office, the legislature has to be has for good reasons to circumscribed the ambit of scope of section 43A, and after looking at these provisions in relation to several other similar provisions, we find that it could be extremely hazardous to accept the arguments put forward by the original petitioner, namely that different acts of misconduct which have been committed in relation to the other issues prior to the date of assumption of office can also from the subject so and so so and so. We are not prepared to do any violence of section or that matter go against the legislative intent, for the simple reason that having regard to the general situation that is prevalent in relation to these bodies, or for that matter elected bodies where there are rivals hostility, it would open virtually a Pandora box, giving races to complaints or anything under such under sin committed in relation to all sorts of situations at any point of time, and the result would be virtually distress. The section, this is very important, limited to situation arises in relation to the period of time when the candidate has held office, and these are the parameters which court will have to be enforced. Here, my lord, the allegation is for 2000, my prior period. It is in this background that we need to interrupt section 43 as clearly limit the act of misconduct to those committed only after the candidate has assumed the office, and during the tenure in office issue relates to corrupt practice, misconduct or other illegalities. Even with regard to the election will have to be dealt with separately. The act itself makes provisions under section 19 and 20. My respectful submission is
facts of this. Where the complainant approached the writ court seeking for a direction, the writ court single bench had issued a direction, and the appellate court said that direction cannot be issued.
My respect
situation where
no 43 applicability, this Vinit Kothari, his lordship has clearly held that, my lord, the 226 is maintainable.
This is against you.
Yes. No. Here, facts is this, my lord. For a moment, I'll submit facts. The offense which they have alleged is for the year of 2010 to 2009 as against the son.
Recommendation made by the regional commissioner.
Yes, my lord.
Don't make this court into an appellate court. You are before a
that is before the secretary now.
So that you go there. Don't come here. Don't replace the constitutional court with the appellate authority.
One second.
Pursuant to which notice is issued and a date was fixed.
Notice also challenged before this court.
Don't make a mockery of this court.
I'm not making mockery of this
You
court.
have to go as an appellate remedy. You have the remedy.
No, appellate already.
Firstly, you have to answer the show cause notice.
I have answered.
Then they'll pass an order.
No, one submission is this, my lord. Whether 43A is applicable or not has to be considered by this court. One second, my lord, if your lordship permits, I'll make submissions insofar as if a recommendation has been passed by the, my lord, the principal secretary, which recommendation has been made against me, they will definitely pass. What is fate of my, because my lord, 43A is not applicable, because that is, this court has hold that prior offense, if any committed, is not applicable to, my lord, present resumption from the year of 2021 to 25. If at all disqualification has been made, that my reputation has gone, because, my lord, my son has done a contract for 2.5 lakh rupees from 2010 to 2000. That period has over. Therefore, court hold that during the tenure, any offense alleged, this I have elected in the year of 2021 to 25. Therefore, my respectful submission is applicable to the facts of this case. The lordship Vinit Kothari also hold that 226.
You keep the judgment with you
No,
without giving us.
I'll give, but now kill.
Show us a judgment which says that in a show cause notice, this court should intervene.
Yes. Got it, sir.
Yes, para.
Para 14. Para. In this present case, the facts, can I read that? Last page. Last page.
Yes.
43A.
Read this para, it is against you.
No, this para
Inquiry cannot be cut short.
cut short. Already inquiry report has been submitted.
Holding elected persons who hold public office accountable for anything that they might have done.
Kindly see
Such an intention cannot be.
There is no further inquiry already recommended for.
The writ petition is only directed against the show cause notice, and this court has come to can be validly issued to the petitioner under Section 43 Act. The petitioner is left free to show cause before the concerned authority in person of said show cause notice.
That is not chief secretary which is made, but here recommendation has been made for disqualification. Kindly see the operative portion in page number 44. 4 of the writ petition. The ಪ್ರಕರಣದ ವಿಚಾರಣೆ ಕಾಲಕ್ಕೆ ಕಂಡು ಬರುವ ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಆಧಾರದ ಮೇಲೆ ಆಪಾದಿತ ಶ್ರೀ ಗಣಪತಿ ರಾವ್ ಹಾಗೂ ಸದಸ್ಯರು ವಜ್ರಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಯಲ್ಲಾಪುರ ಉತ್ತರಗಳ ವಿರುದ್ಧ ಪ್ರಸ್ತಾಪ ಪ್ರಕರಣವು ಸಾಬೀತಾಗಿರುವುದರಿಂದ ಕರ್ನಾಟಕ ಗ್ರಾಮ ಸ್ವರಾಜ್ ಮತ್ತು ಪಂಚಾಯತ್ ರಾಜ್ ಅಧಿನಿಯಮ 93 ಪ್ರಕರಣ 43A1 and 2 ರನ್ವಯ ಸದರಿ ಆಪಾದಿತರ ಸದಸ್ಯತ್ವವನ್ನು ರದ್ದುಪಡಿಸಬಹುದಾಗಿದೆ ಎಂದು ಶಿಫಾರಸು ಮಾಡಿದ್ದಾರೆ. ರದ್ದುಪಡಿಸಲಿಕ್ಕೆ ಮಾಡಿದ್ದಾರೆ.
ಶಿಫಾರಸು ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
Recommendation.
Yes, my lord.
Further action has to be initiated, for in furtherance of which a show cause notice has been issued.
Yes.
This is a preliminary inquiry. Show cause notice has been issued. You have replied to it. That will be considered. If the recommendation is your reply answers the recommendation and the allegation, then they'll drop it. If you are not able to satisfy, then they'll pass orders for which you have an appellate remedy. Coming here, this judgment which you have relied upon is contrary.
No, 43A, that is what I have submitted. The
show cause notice, is there can we interfere? We can only interfere when there's no jurisdiction with the authority. Whirlpool Corporation, Calcutta Discount Company, that's all. If the show cause notice has been issued by authority who has the jurisdiction, you'll have to answer there.
Yes, then I'll withdraw it. I'll withdraw
AGA accepts notice for respond number
1 and 2.
1 and 2.
I'll withdraw it. Withdraw.
After we are 3, 4 yaro.
Jilla Panchayat.
Karwar, Uttar Kannada.
Yellapur. SVIG.
SVIG for 3, 4,
for all.
5.
Yes.
Petitioner is before this court seeking for the following reliefs. After arguing for some time, on being pointed out that what is challenged is a show cause notice, which is required to be replied to by the petitioner, the learned counsel for the petitioner seeks permission to withdraw the above petition. Petition is dismissed. Yes, Mr. Vijay Kumar, you are on mute.
No, my lord, your lordship is able to hear me?
Yes, Mr. Vijay Kumar, allella bidogide.
I'm aged, my lord. I'm quite aged.
But you are not looking familiar at all. You should do something.
I will do it, my lord. This vacation, I'll do it.
We are not used to seeing you like this.
Yes, my lord, sir.
ಸುರೇಶ್ ಭಟ್ ಏನಾದ್ರು ಮಾಡಿದಾರ ನಿಮ್ಗೆ ಅಲ್ಲಿಗೆ ಅಂತ
ಇಲ್ಲ,
ಕೇಳ್ಬೇಕಾದ್ರೆ
ಅವ್ರೇನು ಮಾಡಿಲ್ಲ. Credit should go to my wife, my lord. I said it in lighter way, but I don't attribute anything to her. My lord, what has happened?
Hopefully she is not hearing you.
No, she is not logged in, my lord.
Yes.
But anyhow, my lord, that was on a lighter note. On a serious note, my lord, what has happened is an application filed by me calling for records relating to the mobile of the plaintiffs in a suit for will. In a declaration, suit for will, suit based on will for a declaration. My contention is that that the will is fabricated and concocted. Now he has admitted in his deposition that he has got the mobile and the service provider. Now I have asked for a limited from the superintendent of police to collect from the service provider and place it before the court, because one of the panchapadis is what is the role done by the beneficiary under the will. If I am able to establish that the beneficiary had a role, my lord, the will fall to the ground. But the learned judge now says
seeking for call records, WhatsApp messages, pertaining to mobile number.
that is the plaintiff's mobile number, my lord. He claims under a will said to have been executed by my mother.
This is all covered by privacy. Mr. Vijay Kumar. You can't ask for all this.
No, the difficulty is
you can't ask for this.
No, the difficulty is, if in the will, my lord, if he has participated, taken a lead role in the preparation of the will, which will emanate from the call records, then, my lord, the will itself will go. That's our respectful submission. That is under section 63. We called upon him to produce.
It's a good try to get this, but you should. These are all governed by privacy. You can't get the WhatsApp messages of a private company.
No, but the law enables. That law enables the records being.
Messages?
Section 63, my lord. Section 63 of the Adhiniyam empowers this honorable court, Bharatiya Saksha Adhiniyam, read with order 16 rule 6. Now what I am seeking is production of the documents. In a police investigation, my lord, on section 91 of the CRPC, they will produce along with the charge sheet.
We are in a civil
Everything is
not in a
quite true, my lord. But in a case of this nature, where a will is set up by him, my lord, what is necessary is 63 ನೋಡಿ ಟೈಮ್ ಮಾಡಿ. Electronic records admissibility ಅಲ್ಲಿ ಬರುತ್ತೆ. One that is produced, my lord, he has admitted the number and he has had conversation. He says that important messages are there, I cannot produce. All that questions have been put to him. My lord sees the evidence at page 69. Kindly come to page 69, my lord. I have put several questions to him, saying that why can't you produce your mobile record? Kindly come to that. Manya Nyayalayake, page 69, my lord. ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಅರ್ಜಿ ಹಾಕಿ ತರಿಸಿಕೊಳ್ಳಲು ಏನಾದರೂ ತೊಂದರೆ ಇದೆಯಾ ಅಂದರೆ ಸಾಕ್ಷಿದಾರ ನನ್ನ ವೈಯಕ್ತಿಕ ಹಿತಾಸಕ್ತಿಗೆ ತೊಂದರೆ ಆಗದಿದ್ದರೆ ತರಿಸಿಕೊಳ್ಳಬಹುದು ಹೇಳುತ್ತಾರೆ. ವ್ಯಕ್ತಿಗತ ಎಂದರೆ ಏನು ಎನ್ನುವ ಪ್ರಶ್ನೆಗೆ ಸಾಕ್ಷಿದಾರರು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹೇಳಲು ಆಗುವುದಿಲ್ಲ ಎಂದು ಹೇಳುತ್ತಾರೆ. ನನ್ನ ಕೆಲಸದಲ್ಲಿ ಯಾವುದೇ ಸೆನ್ಸಿಟಿವ್ ಮೆಸೇಜ್ ಇರುತ್ತಿದೆಯಾ ಎನ್ನುವ ಪ್ರಶ್ನೆಗೆ ಸಾಕ್ಷಿದಾರರು ಗೌಪ್ಯ ಮಾಹಿತಿಯನ್ನು ಕಳಿಸಿರುತ್ತೇವೆ ಎಂದು ಹೇಳುತ್ತಾರೆ. Andre is relating to will only. That my contention is that the testator was with him.
Yes.
The
You have
testator,
to
the
establish
lady
it
was,
otherwise, not by WhatsApp messages.
no, it will be there, my lord. It will be there. You would have shared messages, the attestants and all that.
We'll deal with your submission. We have heard
Your
you,
lordship,
we'll deal with your submission.
there is one matter which they have filed, it is listed on 25th, my lord. Your lordship may call this matter also on 25th, where he has filed an application for amendment that was rejected. Your lordships have issued emergent notice to me.
We'll deal with it separately. This will
Your
dispose.
lord, I will do one thing, my lord. I will come there personally on 25th and bring some material, some judgments on the point and then show to your lordship.
Counsel for the petitioner request for the matter to be taken up on 25th February. Request any resident to apply in person. Relist on 25th.
Grateful, my lord. I will appear, my lord. Grateful to your lordship.
This is governed by privacy, Mr. Pujay Kumar. We won't be allowing it. Where is Mr. Shettar, Mr. Sandur? Ready?
Yes, your lordship.
Pass over.
Notice awaited, my lords, in second.
R4 Wakalat.
R4 Wakalat in next matter, my lord.
4 and 5.
Appear for respondent in the other matter.
R12.
Notice.
Not yet returned. Furnishing process fee antiದೆ.
Yes, my lords.
R12 is a party in 23.
My lords.
R12 in 23.1.
Yes, my lords.
Is he a party in 23?
No, my lords. Both are different.
Different. 23.1. Counsel for the petitioner seeks fund is granted 2 days time to make payment of process fee in respect of unserved respondent number 12. If needful is done by 17th, issue notice to the unserved respondent returnable by 16th April.
Much please.
Lordship, in the other matter, my lord, I appear for respondent. In the other matter, my lord, I appear for respondent. Adರಲ್ಲಿ, my lord, I filed an application for vacating the interim order. There are pleadings are complete.
Yardu same connected.
Suit has been stayed at this time of judgment last.
Unless you appear for respondent number 12,
Yes.
you can't take it up.
Party in the other. He's not party in the other petition.
Both are arising of the same suit.
Yes, ma'am.
Different.
No, two connected suits.
Different.
Both will have to be taken.
Interim order.
Date may be given. Please.
Interim order extend 16th April.
Please, because my lord, the last 15 years the suit is.
Appearance axi.
Is not in. Judgment reserve ಆದಾಗ application.
No, my lord. That is
service complete ಆಗಬೇಕಲ್ಲ.
Yes.
Interim order needs to
extended.
No, senior was appearing through VC, my lords.
I appear for respondent in this matter. Land tribunal.
Number 35.
Yes.
Yes.
J. Shetty for 31. ಇದಾರೆ ಇನ್ಯಾರು ಎಲ್ಲ ಬಾಕಿ ಎಲ್ಲ ಸರ್ವ್ಡ್ ಸಫಿಷಿಯಂಟ್ ನೀವಿಬ್ರೇ ಅಲ್ಲ?
Yes.
Mr. Alikeri, ready?
My lords, if you kindly have it next week, my lord, I'll come with some this thing. Today, my lords, I little unwell, so could not come, my lords.
Little unwell.
little
unwell ಅಂತ ಆಮೇಲೆ ಕೆಮ್ಮದು counsel for the petitioner submits that he is under the weather today. He seeks fund is granted 2 weeks time to get ready and address arguments. Relist on 14th March.
Please.
I'm grateful. The interim order may kindly be.
Interim order earlier granted is extended.
Please.
Grateful, my lord.
As for petitioner,
Lord, on the last occasion, the learned AAG had submitted that there are talks with regarding to compromise. Lord, since AAG is on his legs in court all too, my lord.
Lords, you given proposal, lords, you given proposal, lords. Lords, you given proposal. Lords, we need another 10 days time, lords.
10 days time.
Please, lords.
both the councils submit that the settlement talks are in an advanced stage. They seek for and are granted 10 days time to report further progress. Released on 7th, 14th March.
That's interim order may be accepted.
Interim order earlier granted is extended till next.
Lord, learned age on.
The counsel for the petitioner and the learned additional advocate general submit that advanced stage.
My lord, my application for recalling is pending, my lord. That is not
Recalling is pending.
pending, my lord. Not dismissed for, my lord, non-compliance of office objection.
Call order. Comply ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀನಿ, my lord. Complied all office objection.
ಎಲ್ಲಿ ನೋಟ್ ಎಲ್ಲಿ? IA 1 of 20, sorry. Recalling application ಯಾವ್ದಪ್ಪ IA?
IA 1 of 2024, my lord.
24.
4/9/2024, my lords, it was dismissed for default.
Dispensation. Recalling. IA 1 of 24 has been filed for recalling the order dated 4/9/2024, dismissing the above petition for non-prosecution on account of non-compliance with the office objection. Counsel for the petitioner has filed IA 1 of 2025, seeking for dispensation of production of certified copy of annexure
Annexure, my lord, DA.
K.
Please, my lord, annexure K.
In annexure K, ಏನು?
My lord, deputy commissioner order. Impugn order.
The submission of learned counsel for the petitioner is that annexure K is the copy of the order which has been served on the petitioner. In that view of the matter, accepting the reasons stated in support of IA 1 of 25, production of certified copy of annexure K is dispensed with. In view of the dispensation, the compliance of office objection having been made, IA 1 of 24 is allowed. The order dated 4/9/24 is recalled. The petition is restored to file. Yes. Yeah, who are the respondents?
My mutation entries were not set aside by the deputy
And
commissioner.
AGA accepts notice for respond number 1, 2,
1 to 4 and, my lords, 9.
and 9. KSFC arrow.
KSFC Sharad Magdum. Sharad Magdum.
Sharad Magdum for respond number 7. Issue emergent notice to respond number 5, 6, and 8.
Please.
Returnable by 24th March.
Please, my lords. Much obliged.
Pray for a week's time accommodation, my lordship.
Adverse inference would be drawn and dismissed.
I'm proxy counsel, my lords.
Where is the actual counsel?
It's in Bangalore, my lordship.
Why did he go to Bangalore today? He has to go on Monday, alva. ಹೇಳಿದ್ರು. Monday and Tuesday we have exempted his appearance, not today. At the request of counsel for the, on behalf of the counsel for the petitioner, a request is made for an adjournment to comply with the order dated 1/2/2025. If the same is not complied by 21st, the petition would be liable to be dismissed for non-prosecution. Relist on 21st.
Grateful notes.
Certified copies of the annexure D and E. I am here with submitting, my lord.
Any dispute, you are submitting?
Yes, my lord.
Counsel for the petitioner has filed a memo enclosing the certified copy of annexure D and D. The same are taken on record. In that view of the matter, IA 1 of 23 does not survive for consideration. IA 1 of 23 is dismissed as not pressed.
Please, my lord.
Yes.
My lord, survey number 455/A, measuring 4.49 acres at Timbalapura.
That come up for dispensation.
ನಮ್ಮ dispensation ಅದೆಲ್ಲ ಒಟ್ಟಿಗೆ
Maybe passed over.
pass over reach ಆಗಲ್ಲ.
Copy.
At the request of counsel for respond number 5, relist on 24th.
Please, my lord.
During the pendency of the above matter, petition number 1 expired on 10/3/24. Hence, IA 1 of 24 has been filed on accepting the reason stated therein, the delay of. Here,
No
there
delay,
is no
madam.
delay in the filing of the said application. As such, accepting the reason stated in support of the said application, the person named therein are brought on record as P1A2.
3, madam. A to C, my lord.
A to C. Counsel for the petitioner to carry out necessary amendment and file amended cost title.
Please.
And what is this? Respond 1 to 6, Bari Testator.
State, your lord. Please.
Nobody else?
Nobody else.
Relist on 24th.
Please.
Lords, petition seeking costing of order passed by Deputy Commissioner, my lords. I am the fifth purchaser.
Lakshmesh P. Matguppe. Yarappa? Lakshmesh Matguppe. First time ಹೆಸರು ಕೇಳ್ತಾರೆ.
Yes.
Is he ವಕಾಲತ್ ನೋಡಿ?
ಅಲ್ಲ, he has filed vacating also.
Yes.
ಇಲ್ಲ ಇನ್ನೇನಾದ್ರು ಹೆಸರು ಇದೆಯಾ ಅಂತ.
ಅದೇ.
ವಕಾಲತ್ ನೋಡಿ. ಒಂದೇ ಹೆಸರಾ? ಸ್ಟೇ ಇರ್ಬೇಕಲ್ಲ. ಸ್ಟೇ ಹುಬ್ಳಿ.
ಯಾರು ಇಲ್ಲ ಇಲ್ಲ
ಬರ್ತಾರ ಅವರು ಏನು ನಾಟ್ ಹರ್ಡ್.
ಫಸ್ಟ್ ಟೈಮ್ ಹಿಯರಿಂಗ್ ದಿಸ್ ನೇಮ್. Look.
Accepting the reason stated in support of IA 1 of 24, production certified copy of Annexure D is dispensed with. None appears for respond number 5 in order to provide one more opportunity for his appearance, for representation of, for respond number 5 to be represented. Relist on 17th March. Interim order earlier granted is extended till next day. If none were to appear for respond number 5 on the next date of hearing, the matter would have to be considered on the basis of submission made by the counsel for the petitioner.
Please.
My lords, a week's time may be granted, my lords.
Yes, when will you take action?
Lords, we have sent for the approval, we sent the proposal for approval of the Deputy Commissioner, who in turn has raised 8 queries. Lords, we are complying with it. By Monday, my lords, we will be sending back once again, we will be sending proposal to the Deputy Commissioner. Once he approves it, then my lords, immediately we will take.
ಎಷ್ಟು items raise ಮಾಡಿದ್ರು ಅವರು?
8 queries, my lords.
Learned counsel for respond number 2 and 3 submit that 8 queries having been raised by the Deputy Commissioner, respond number 3. The respond number 2 corporation is in the process of complying and answering those queries, which would be so done by 17th February, and a reply sent to the Deputy Commissioner for necessary action. He submits that it is thereafter for the Deputy Commissioner to pass necessary orders. Relist on 25th to ascertain the progress in the matter.
Please, bless.
Accepting the annexure E is dispensed with. Who do you want to implead?
For impleading, my lord.
Yarna.
The owner of the land, my lord, petitioners have sought for regularization of the land.
And there is a owner of the land.
There is a earlier owner, my lord, who is having the excess land, and that land, my lord, is sought for regularization.
Ceiling limits. Issue notice on IA 1 of 25, returnable by ಎಲ್ಲಿ ಇದ್ದಾರೆ ಇವರು? ಬೆಳಗಾವಿ. Written by 21st March.
Lord, there is another application for amendment of the petition.
And what is the amendment?
Amendment, my lord, I have sought for interim prayer against him.
Accepting the reasons stated in support of IA 2 of 2025, there being additional grounds for interim prayer and the interim prayer sought for under the said application. The said IA 2 of 2025 is allowed. The respondent, the proposed respondent number 6 is restrained from alienating any portion of the property subject matter of the above writ petition till the next date of hearing.
Directed take notice. I may be directed to take notice.
Agilva? And AGA accepts notice for respond number 1 to 5. Process fee and copies to be furnished by end of day 17th February, failing which the interim order will stand automatically vacated.
Pleasure.
Petitioner father filed an obstruction application in the EP proceedings, lordship. The petitioner's father in the EP proceedings filed an obstruction petition, lordship. During the pendency of the my petition, the trial court has issued the delivery of possession warrant, lordship. That is the impugned order, lordship.
Page number?
Page number 18, lordship. Please, sorry. Page number 138, lordship. The respondent number 1 and 2 filed 2 application, lordship. I number 18 and 19, lordship. Relevant is 139, lordship. Page number 139, lordship.
Where is the 21 Rule 97 application?
Please, lordship. Annexure. Page number 130.
130 is the order. Application ಅಲ್ಲಿ. Page 52. 52 is the objection.
Petition.
IA 847.
Yes, lordship.
You are
My obstruction petition not at all discussed with lordship in this impugned order, lordship.
who is the objector?
Kindly see the findings of the trial court, lordship. Page number.
Let us first see your application.
Please, lordship.
Damava
Annexure C, lordship.
Irebasanagowda Malli Patil.
Annexure C, lordship. Page number 40.
Malli Patil.
Genealogy, kindly see, lordship.
Koda is Basamma
branch, lordship.
Son.
Please, lordship. Present petitioner number 1 is the wife of Irebasanagowda.
Who is the decree holder?
Respondent number 1 and 2, lordship.
Devappa is the decree holder. Shivamma and Tottappa.
1 Gauramma.
Judgment debtors. What was the suit filed for?
Suit for declaration and injunction, lordship. Lordship, genealogy, kindly see page number 48, lordship.
For possession.
Son Sangappa's wife Gauramma. She executed a will, lordship, in favor of the respondent number 1 and 2, lordship.
Now they have filed a suit, my lords.
Suit for declaration and injunction.
Separate suit has been filed by them.
So you will have to succeed there.
Yeah.
This is not a suit for partition for you to come on record.
They have filed a separate suit.
It's a declaration as regard the will of Sanna Sangamba. And you are claiming a right because you are a joint family member, as regards which you have filed a suit in.
He has also
partition.
filed a suit and that is
For
pending before the
partition.
trial court, yes.
So if you succeed there, then you can proceed against them. You can't come in the way of their taking possession.
Position handover ಆದರೆ very difficulty to.
You have been set up.
ಅಲ್ಲ ಬೇಕಾದ್ರೆ ಸೂಟ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ಕೆ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ಬೋದು ಸ್ವಾಮಿ ಡ್ಯೂರಿಂಗ್ ದ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದಿ ಇಪಿ ಲಾಟ್ಸ್.
Suit progress ಮಾಡಿ. ಇದು application 5 years back you have filed and not progressed it.
ಹಿರಿಯ ಬಸ್ಸನ್ನು ಕೂಡ subsequently died ಲಾಟ್ಸ್.
2018 is the application.
Please. Subsequently the one of
you came on record. A 21 rule 99 application is pending for 7 years.
Subsequently my father has died in the year of 2021 lordship.
ಆಯ್ತಪ್ಪ 3 ವರ್ಷ ಅವರು ಮಾಡಲಿಲ್ಲ.
ಅಲ್ಲ ವೆರಿ
4 ವರ್ಷ ನೀವು ಮಾಡಿಲ್ಲ. In a execution petition 21 rule 99 is pending for 7 years.
Please lordship.
You had enough and more time. ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ರಿ 7 ವರ್ಷ ಸುಮ್ಮನೆ ಕೂತ್ಕೊಂಡು?
ಇಲ್ಲ we came on time lots.
ಇಲ್ಲಿ ನಮ್ಮ ಹತ್ರ ಬಂದ್ ಗಲಾಟೆ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರಿ? 7 years on this application.
We are proceeding my lords since the
petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that without considering an application filed by the petitioner's father under Rule 99 of Order 21 of the Code of Civil Procedure, the trial court has passed orders on an application under Rule 95 of Order 21 directing delivery of possession by issuance of a possession warrant. The submission of learned counsel for the petitioner is that the petitioner's father having objected to the execution of the decree and the petitioners thereafter having come on record, the said application ought to have been considered, and unless orders are passed thereon, possession warrant under Rule 95 of Order 21 could not have been issued. Having perused the records, it is seen that the application under Rule 99 of Order 21 had been filed on 2nd August 2018, and thereafter the father of the petitioner who had filed the application having expired, the petitioners came on record on
6/3/2023 lordship.
6/3
2023 lordship.
2023.
Please lordship. I number 15 to 17 lordship.
he expired my lords in the 2021.
Expired on ಯಾವ date?
12 to 21 lordship.
12 to 2021. The petitioners came on record as his legal representatives on
6/3/2023 lordship.
6/3/2023.
As per order of the I number 15 and
15 to 17.
please lordship.
The petitioners, neither the father of the petitioners nor the petitioners have sought to address arguments on the said application, and the said application has been only been adjourned. It is taking that factor into account in the impugned order that the trial court, the execution court, issued the possession warrant. Apart from the above, though not mentioned in the said order, as per the submission of Sri B. Sharnabaswal and its counsel for the decree holder, the petitioners have filed a separate suit.
Invoice number 8
and separate possession in
OS number 8 of 2020.
OS 8 of 2020, which is pending consideration. If that be so, it is for the petitioner to establish their right in the separate suit which has already been filed by them. And in the event of their being successful, they could always execute that decree against the petitioner, against the decree holder. The execution of a decree passed in OS number 113 of 2008 cannot be therefore kept in abeyance till the said orders, till the said decree, said suit is considered. In that view of the matter, I do not find any infirmity in the order passed by a trial court. No grounds being made out, the petition stands dismissed. A perusal of the impugned order indicates that the trial court, that the additional civil judge and JMFC Koppal has not complied with the circular dated so and so. Hence, additional registrar judicial is direct forward a copy of the said circular to the additional civil judge and JMFC coupled for compliance in future. Pending IA number 1 of 25 does not survive for consideration. ಎರಡೆರಡು ಸತಿ ಬಂದಿದೆ ನಿಮ್ಮ ಹೆಸರು. ದೀಪಕ್ ಎಸ್ ಕುಲಕರ್ಣಿ ಬೋಲ್ಡ್ ಅಂಡ್ ದೀಪಕ್ ಎಸ್ ಕುಲಕರ್ಣಿ.
Order of accepting the court commissioner report, my lord, that by order dated 23/9/2024 is challenged, my lord, in FDP number 65/2019.
Yes.
The petitioner is a respondent before the trial court, whereas the respondent is a petitioner in FDP proceedings, my lord. The respondent has filed a suit for partition and separate possession, and that suit came to be decreed, my lord, granting legitimate share. And thereafter we have filed an appeal that also came to be dismissed, and thereafter subsequently they have filed a final decree proceedings, my lord. And the court commissioner, I number 4, they have filed, my lord, as per annexure D at page number 56 for appointment of court commissioner. And court commissioner has submitted a report, my lord, that the suit property cannot be partitioned, as there is no access to the property anywhere except the front side, and it can only be auctioned, and the sale proceeds can be distributed equally between the parties.
You want to buy out the share?
Yes.
You want to buy out their share?
No, my lord, that my parties are 73 years and 80 years old, my lord, and along with the family members, they have been residing in the suit property, and the suit property, your honor.
Can you buy out their share? Can you make an offer? Preemptive right you want to excise?
We are ready to
Preemption
purchase.
right.
They are not in a position.
We are ready to purchase, madam, and also we are ready to sell the property our portion, madam. Either one of the option.
My submission is that the property can be equally partitioned, and both the parties can be reside there in the suit
Width
property.
is 12.3 feet, 6 feet by 12.3 feet.
No.
3 by 6 ಮಾಡಬೇಕಾ?
12 feet, the front portion is, my lord, it is about.
Lord, here it is the sketch, my lord.
6.5
At 3 direction, my lord, there is a wall, my lord, and only front portion of a portion, my lord.
6 feet is the frontage.
That is, my lord. That is.
6.5 feet to each person will get the 6.5 feet.
6.5 by 12 feet ಆಗುತ್ತೆ. 6.5 ಆಗಲ್ಲ. 6.5 ಅಲ್ಲಿ 3 feet ಬರುತ್ತೆ ನಿಮಗೆ.
ಇಲ್ಲ, my lord, that total is 12 feet 3 inches to the front portion, and at the back portion 18 feet 8 inches. At court commissioner report, my lord, at page number.
It says otherwise.
59.
But Mr. Kulkarni, even if you accept your submission, your submission will accept it and fit body. It will become 6 feet by 18 feet.
How each person will get, my lord.
6 feet by 18 feet. ಏನಪ್ಪ ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ, the court commissioner at page number 69.
They are ready to sell their portion.
ಅಲ್ಲ, one.
And they are also ready to purchase your portion. What is the price at which you will sell?
My lord, I have not asked, my lord, but my party is, my lord, given the consent that, my lord, we are ready to purchase or we are ready to buy them.
So what price are you willing to sell?
No,
find out.
Please, my lord. I will find out.
If they are ready to sell, take it.
Since birth, my lord, they have been residing in that property.
ಅದಕ್ಕೆ ತಗೊಂಡು ನೀವು full property ಅಲ್ಲಿ ಇದ್ಬಿಡಿ.
ಅಲ್ಲ, my submission is the respondents are permanent residents of Bangalore, my lord, only with an intention to sell that property by colluding with the court commissioner.
ನಿಮಗೆ ಕೊಡ್ತಾ ಇದಾರಪ್ಪ, ನಿಮಗೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. No need to auction. ಅರ್ಥ ಮಾಡ್ಕೊಂಡ್ರೆ ಅವ್ರು ಹೇಳಿದ್ದು.
But the property's financial condition is not good.
So you have two options. Either auction ಬೇಡ ಅಂದ್ರೆ you can sell your property to them, your 6 by 18, or buy their 6 by 18 feet. If you are not willing to do both, then auction ಆಗ್ಬೇಕು.
My lord, my last submission is that the property can be partitioned by
6 by ಇದು ಮಾಡಕ್ಕೆ.
The front portion, if the petitioner takes.
ನಿಮಗೆ ಬೇಕು front portion, back portion ಅವರು ಕೊಡಬೇಕು, ಅದಾಗಲ್ಲ. It will be split into 6 by 18. You can't take the front portion and back portion access ಹೆಂಗ್ ಕೊಡ್ತೀರಾ?
Since birth I am residing that property.
ಆಯ್ತು, passage ಕೊಡ್ತೀರಾ?
ಅಲ್ಲ ಪ್ಯಾಸೇಜ್ ಕೊಡ್ತೀವಿ
ಎಷ್ಟು ಫೀಟ್ ಪ್ಯಾಸೇಜ್ ಕೊಡ್ತೀರಾ?
3 feet ಪ್ಯಾಸೇಜ್ ಇದೆ.
ಕೊಡ್ತೀರಾ?
ಎಸ್. ಅಲ್ಲ
ಇನ್ನು ಅದಕ್ಕೊಂದು 2 ಲಿಟಿಗೇಷನ್ ಬರುತ್ತೆ.
ಅಲ್ಲ ಇಫ್ ದ ಫ್ರಂಟ್ ಪೋರ್ಷನ್ ಆ ರೀತಿ ಮಾಡಿದ್ರೆ ಆಗ್ಬೋದು ಅಂತ.
ನೀವು ಲಿಟಿಗೇಂಟ್ ಡೈರೆಕ್ಟ್ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಕೌಂಟರ್ ಪಾರ್ಟ?
ಕೌಂಟರ್ ಪಾರ್ಟ್.
ಅವ್ರ ಹತ್ರ ಮಾತಾಡಿ ಲಿಟಿಗೇಂಟ್ ಹತ್ರ, ನೀವು ಕೌಂಟರ್ ಪಾರ್ಟ್ ಮೇಲೆ ಹೋಗ್ಬೇಡಿ. ಡೋಂಟ್ ಫರ್ದರ್ ದಿಸ್ ಕೈಂಡ್ ಆಫ್ ಲಿಟಿಗೇಷನ್. ನೀವು ಪ್ಯಾಸೇಜ್ 4 ಅಡಿ ಇಲ್ಲ 5 ಅಡಿ ಪ್ಯಾಸೇಜ್ ಕೊಡಬೇಕು. 12 ಅಡಿಯಲ್ಲಿ 5 ಅಡಿ ಇಂಟು 9 feet. You'll have to give free. Your client will suffer unnecessarily if we accept this kind of a proposal.
Yes.
Don't go by, even if there's some ego involved, there's no point in giving 5/9.
No question of ego, my lord.
5/9 passage kotre 5 adi antu kodlebeku.
My lord, only one last submission at page number 61. There is a total width in the front portion is 12 feet 3 inches, and at the back portion 18 feet 6 inches. And if we equally by building a line, wall of one brick wall, my lord, at the center, my parties are ready to reside comfortably without any.
5/9 feet you have to give them passage.
Alla passage
or back andre
in the front portion both will get the property, my lord. Exactly at page number 61.
6/18
It's not possible.
ಏನಾಗುತ್ತೆ? 6/18 feet. ಆ ಕ್ಯಾಮ್ರಾ ಇಂದ ಈ ಕ್ಯಾಮ್ರಾ ವರೆಗೂ 6 feet would be the width of the property.
Yes.
ಅಲ್ಲಿಂದ ಈ ಟೇಬಲ್ ವರೆಗೂ.
I will discuss with the parties.
That is not possible. If you want to, if you want front portion and back portion, again you lose 5/9 feet, for which they won't pay. Both of them don't make sense. Either you auction and share the money, ದುಡ್ಡಿಲ್ಲ ಅಂದ್ರೆ ಇಬ್ರು ಶೇರ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಇಲ್ಲ you buy them or they buy you. ಆ ದುಡ್ಡು ಎಲ್ಲರೂ ಯೂಸ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಅವ್ರು ಸರಿಯಾಗಿ ನಿಮ್ಗೆ ಕೊಡಲ್ಲ ಅಂದ್ರೆ ಆಕ್ಷನ್ನೇ ಆಗ್ಲಿ, ಯಾರು ಬಂದು ತಗೊಂಡ್ತಾರೆ.
Only problem is that, my lord, at this age they cannot.
If you are willing to buy, then we'll speak to Mr. Purohit and see if you can give some installments.
Yes, I will discuss.
If you are ready, then we can intercede. 2-3 installment ಅಲ್ಲಿ ಏನೋ ಮಾಡ್ತೀರಾ ಅಂತ ನೋಡ್ಬೋದು.
Yes.
Don't make it like this. Your client will suffer. After arguing for some time, both the counsel seek for and are granted a week's time to make their respective submission as to at what price each of them is willing to sell their property to the other.
Yes.
Relist on 21st February.
Please.
ಸರಿಯಾಗಿ ಯೋಚನೆ ಮಾಡಿ ಅಡ್ವೈಸ್ ಮಾಡಿ. ಯಾರಿಗೆ ಪೆಟಿಷನರ್ಗ ಇನ್ನ ಇವಾಗ 6 ವರ್ಷ ಆದ್ಮೇಲೆ ಏನಿದೆ ಎಲ್ಲಾರ ಹೆಸರು ಏನೇನಿದೆಯೋ ಎಲ್ಲಾರು ಲಿಸ್ಟ್ ಮಾಡಿಸಿ ಎಲ್ಲ ಕೊಟ್ಟು. Respond number 9.
My lords, I am appearing on behalf of respondent.
ಈ respond number 4, 8 to 10 and 12 also ನಾಗ್ನೂರಿ ಅವರಿಲ್ಲ. ಯಾಕಪ್ಪ ಇದು? Issue court notice to the petitioners returnable by 28th April. Issue court notice to respond number 4 to 8. The counsel for respond number 4 to 8 and 10 to 12 has expired. Hence issued court notice to respond number 4 to 8 and 10 to 12 returnable by same date.
My lords, one submission, my lords. There are other two writ petitions which has to be connected with this.
Connect with WP. Adral appearance hakidara.
Yes,
Anybody
my
else has appeared on behalf of Mr. After Mr. Nagnuri expired?
No, my lords, I'll have to check with who have. I do not have instruction regarding the appearance on behalf of respondent number 9 in those petitions.
There one kelsa madi. Connect with so and so and relist on 17th.
Please.
ಎಲ್ಲದರಲ್ಲೂ ಒಟ್ಟಿಗೆ ನೋಟಿಸ್ ಹಾಕಿ.
36
Extension of time.
Trial court has sent a letter for
ಯಾರು ಬಿಡ್ತಾ ಇಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ಕೆ.
defendant number 1 and 2, they are filing applications.
Contesting
Defendant 1 and 2 ನೀವು ಅವ್ರ ಮೇಲೆ ಹೇಳಿ ಅವ್ರು ನಿಮ್ಮ ಮೇಲೆ ಹೇಳ್ತಾರೆ.
hotly contested matter. The value of the property is much more than.
When Mr. Shetty is there, it has to be contested.
36 and 38, same.
Was listed on daily basis.
Yes, sir.
Amendment, interlocutory application 61.
Different purchases are also there actually.
83 IS. Stayed by this court in 107711.
Yes. Because the defendant number 1 and 2 filed again.
Again classification of the 1077 CPC na?
James, CPC. Stay of the only a portion, operative portion of the order, not the proceedings has been stayed. Proceedings is not stayed.
The second additional senior civil judge and JMFC Ubballi, as wide order, letter dated 27 January 2025, sought for extension of time to dispose the suit in OS number 259 of 2013 on the ground that there are several applications which have been filed by the parties post the directions issued by this court, and as said the suit could not be disposed. A perusal of the letter indicates that there are as many as 83 applications which have been filed. Yaar file madiddu?
Different.
Yes, sir.
83 applications.
Defendant one application only we have filed. Then first two applications.
83 ಅಲ್ಲಿ ಒಂದೇ ಒಂದು ನಿಮ್ದ, 82 ಅವ್ರದ.
Different purchasers.
Different purchasers are also there. They are also making.
83 applications have been filed. In that view of the, though there is a reference made to an order of stay in WP number 107711 of 2024, Sri Mahesh Vadiyar, Learned Counsel for Respondent, submit that only the stay is in respect to the order and the proceedings have not been stayed.
Yes, sir.
In that view of the matter, the pendency of WP number 107711 of 2024 would not come in the way of the trial court taking up the matter and proceeding therewith.
Yes, we requested the court also by produce.
Shetty and Sri Mahesh Vadiyar, Learned Counsel for the petitioner and respondent respectively, submit that they would not be filing any unnecessary applications or seeking for unnecessary adjournments. The trial.
In fact, Malad, they are trying to.
Argument argument stage.
They are trying to settle the matter also between the brothers.
On their own behalf, as also on behalf of the counsel appearing before the trial court, submit that they would not be filing any unnecessary application or seeking unnecessary adjournment. Their submission is placed on record. If any unnecessary applications are filed, the trial court would be free to take such action and pass such orders as may be deemed to be as deemed fit by the trial court. The time granted. You again stage any
argument ಇದೆ.
Argument.
ಇಲ್ಲ ಆಗಿದೆ. ಆರ್ಗ್ಯುಮೆಂಟ್ ಸ್ಟೇಜ್ ನಲ್ಲಿ ಮತ್ತೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು. ಇದು ನಾವು ಸ್ಟೇ ಮಾಡಿದ್ದು. the stay agid application amendment. Already the properties are in.
Proceedings can go on.
Proceedings again, we have produced and requested the court. There's no proceedings stayed. Lordship,
ವೆಬ್ಸೈಟ್ ಇಂದ ಪ್ರಿಂಟ್ ಔಟ್ ತಗೊಂಡು ಕೊಡಕ್ಕೆ ಎಷ್ಟು ಹೊತ್ತು?
ಅಲ್ಲಲ್ಲ, ಸರ್ಟಿಫೈಡ್ ಕಾಪಿನ ಕೊಟ್ಟಿದ್ದೇವೆ. ಇನ್ ಸ್ಪೈಟ್ ಆಫ್ ದಟ್ ದಿ ಕೋರ್ಟ್ ಸೇಸ್ ದಟ್ no, it's pending, we will not.
The time sought for by the trial court is extended by a period of 3 months from today, making it clear that the trial court can proceed with the matter since there is no order of stay of proceedings in WP number 107711 of 2024.
38 is also same.
Same suit, huh?
Same suit, same application.
38, same order.
Same order, same suit and same.
Same order.
Yes.
83 IAS ಏನ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕು ಅಂತಿದ್ದಾರೆ. ಇನ್ನೊಂದು 17 ಹಾಕ್ಬಿಡಿ, 100 ಆಗೋಗ್ಬಿಡುತ್ತೆ.
Property value is also more than 100.
That doesn't mean go on filing IAS like that. Don't harass the trial court ಅಲ್ಲಿ. ಪಾಪ ಅವ್ರು ಏನು ಹೇಳಕ್ಕಾಗಲ್ಲ ಅಂತ ನೀವು 83 IA ಹಾಕಿದ್ರೆ ಹೆಂಗೆಪ್ಪ?
Other urban sealing action.
You are harassing the court by filing. ಏನ್ ಇಶ್ಯೂ ಏನು?
Partition.
There are so many properties.
Mediation refer ಮಾಡೋಣ.
In the heart of the city. ನಾವು ಎಷ್ಟೊಂದು ಹೇಳಿದ್ವಿ ನಾವು.
ಹೋಗಿದೀಯಾ mediation ಗೆ ಯಾವಾಗ್ಲಾದ್ರೂ?
ಕೊಡ್ತೀವಿ.
Has it been referred to mediation earlier?
ಇಲ್ಲ ಮಾಡಿ.
ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಮಾಡಿದ್ರೆ
ಅಲ್ಲಿ ಮಾಡಿದ್ರು, ಅಲ್ಲೇ ನಡೀತಾ ಇದೆ. But they are defendant number 1 and 2 are not. Other brothers are agreeable. Around side. Only defendant number 1 and 2 are not agreeable. There.
ಮಂಡ್ಗಣಿ ಅವರ ಹತ್ರ ಕಳ್ಸ್ಬಿಡೋಣ.
There is also a will in question. Will has been disputed by them.
Whatever it may be, it can be settled if parties want it.
No.
Otherwise, this is going up to the Supreme Court the way you are conducting.
They are trying to.
83 IA ಅಂದ್ರೆ.
ಅಲ್ಲ 83 IA not by.
Appeal, cross appeal, specially petition.
Matter pertaining to urban sealing. Urban land sealing act also was pending before the Sambar court. Now it has been.
Is willing to speak for settlement, and we can refer to mediation.
We are ready.
Operation successful, patient dead. There's no point.
ಅವ್ರು ಒಪ್ತಾ ಇಲ್ಲ, ಯಾಕಂದ್ರೆ ಮತ್ತೆ ಮೊನ್ನೆ ಜಗಳ ಏನೋ ಮಾಡಿದ್ದಾರೆ. ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಎಲ್ಲ ಆಗಿದೆ. Among the brothers.
Among the brothers, there is some dispute. But taking advantage of some situation, some strangers are encroaching upon the land. That's the power.
ಜಗಳದಲ್ಲಿ ಮೂರನೇ ಒಂದು ಲಾಭ
ಆಗ್ತದೆ.
Then both of you will not have anything. It's up to them, up to you to advise them and up to them to.
I'm sincerely advised, and they agreed for Manad. Even they have to take, they will take the lesser properties.
We will put the words. In fact,
mediation refer ಮಾಡೋಣ ಏನು?
ಮಾಡ್ಬೋದು.
Try ಮಾಡಿ.
I'm ready.
Who will be the mediator? Who do you think would, between both of you, who do you think can effectively speak to them?
Dinesh. ಯಾಕಂದ್ರೆ ದಿನೇಶ್ ಅದಾರ ಇಲ್ಲ, ಶಿಲ್ವಂತ ಬೇಡ. Dinesh Kulkarni
is not mediator.
Or what my learned friend, you suggest, if any other mediator suggest, I have no objection.
Both of you, who do you think, you know your clients?
Yes, yes.
Mediator who can handle them and advise them properly and guide them.
Dinesh Kulkarni is.
Dinesh Kulkarni. Though the proceeding shall go on, the matter is referred to mediation with the consent of both the counsels. Shri Dinesh Kulkarni, a practicing mediator, the advocate and practicing mediator before this court, he is appointed as the sole mediator to try and resolve the disputes. Since the order is passed in the presence of both the counsels, the parties shall be present before the mediator at 2:30 p.m. on
ಯಾವಾಗ
20th.
20th.
On 20th February 2025. Released on 27th February to ascertain the progress in the mediation.
Yes.
Where is Mr. Dinesh Kulkarni? Ilva. Bandav Geli. Both matters. Connect madbidi adanu.
Because there are about 256 respondents, sir. Only 1 to 9 are the relevant immediate
Family members.
family members. The plaintiffs 1 and 2 and the defendants 1 to 9 are only the others need not.
ಅದರಲ್ಲಿ ಎಲ್ಲಿ ಚನ್ನಬಸವ
ಅವ್ರದ್ದೇನು ನಾವು ಇಲ್ಲ
ಬರ್ತಾ ಇದೆ.
Because
it is made clear that the mediation is between the family members for now, and once that is resolved, the rights of other parties could
will be resolved.
I am appearing for a petitioner, my lordship. Kindly have 2 weeks time to do.
Counsel for the petitioner seeks bond is granted 2 weeks time to file necessary application, bring the legal representative deceased, respond number 9, 18 and 23 on record.
9 and 23.
9 and 20.
18 no?
18 minutes on last occasion, 18 CLRs were so moto appeared.
Impleading application has been filed by them.
They are on
9
record.
and 23.
9 and 23.
If application, necessary application is not filed by 7th March, released on 14th March for dismissal.
Please.
Appear for response. File vacating stay also, my lord.
My lord, it will be taken next week. It will be taken next week.
Counsel for the petitioner seeks bond is granted 10 days time to comply with the pending office objection. If the same is not complied by 28th, released on 7th for dismissal.
Please.
26.
I have filed no objection. Wakalat not. Earlier counsel has filed no for retirement.
Srinand A. Pachapure has entered appearance for the petitioner. Hence, the memo filed by Sri Girish Yadwad for retirement is accepted. He is discharged from the matter.
Next week.
ಇಲ್ಲಿ ಶೆಟ್ಟಿ ಅವರೆಲ್ಲದು ನೀವು ರೆಡಿ ಇದ್ದೀರಾ?
Monday or Tuesday.
At the request of counsel for the petitioner, released on 24th.
Interim order may kindly.
Interim order earlier granted is extended till next day.
Please.
None appears for the petitioner. 10 days time is granted to make payment of necessary process fee in respect to unserved respondents. If needful is done by 28th, registry is directed to issue notice to the unserved respondent returnable by 28th April. If needful is not done by 28th, released on 7th for dismissal.
42, yes, party.
Counsel for the petitioner has filed a memo seeking for dispensation notice to respond number 2 and 3.
My lord.
Accepting the said memo, notice to respond number 2 and 3 is dispensed with at the sole risk, cost and peril of the petitioner. Needless to say, respond number 2 and 3 will not be bound by any orders passed in the present matter. Yes.
My lord, we have filed a memo seeking dispensation.
Aitu allowed. Merits
Need to be extended, my lord. Stay need to be extended.
Argument ಮಾಡಬೇಕು.
Sir, next week.
ನೀವೇ ಮಾಡ್ತೀರಾ?
My senior mother is dead, sir. So.
Yes, but. The request of counsel for the petitioner released on 14th March, interim order earlier granted is extended till next day. ಏನಿದೆ? 10 days time is granted to none appears for the petitioner. 10 days time is granted for compliance with the office objection. If office objection are not complied by next date, the petition would be liable to be dismissed to non-prosecution.
Lord,
Based on 14th March.
Lord, in this, their grant itself has been cancelled. Now, having taken the benefit of the interim order, they are running the school, and now they have filed an application seeking amendment for quashing of that grant in aid, which is,
ಇದು ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ dismiss for non-first.
ಯಾಕಂದ್ರೆ there is an interim order operating, we have to provide the benefits of the government to the institution.
Week's time is granted to comply with the office objection. If not complied by 21st, relist on 25th for dismissal.
Please.
Your Honor, notice is issued. So, process fee is paid today.
Counsel for the petitioner submitted process fee. What about office objection?
Yes, Your Honor.
Kept
They have
open.
kept open.
The process fee is being paid. Registry to verify if needful has been done, issue notice to answer respond returnable by 28th April. Interim order idea?
No.
Right, next.
Next, typed copy, Lordship. Objection is the annexure typed copy, Lordship. It is the
Typed copy of
annexure, Lordship. Legible and readable, Lordship.
B page number?
Page number 39, Lordship.
Page number?
39, Lordship.
39.
Mandamus, Lordship. One time exit scheme, Lordship.
A
But it is
perusal
served the
of
copy.
annexure E indicates that the same is legible, hence office objection. B and D indicated both are legible.
Please,
As
Lordship.
such, office objection at serial number 18 is overruled.
Standing counsel copy ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ ಅನುಪ್ ದೇಶಪಾಂಡೆ ಅವರಿಗೆ ವಿಟಿಯು ಅಪಿಯರ್ ಆಗ್ತಾರೆ.
Deshpande, he is directed to accept notice for respond number 1.
Please, Lordship.
Gokte Institute
I take notice, Lordship.
issue notice
To respond number 2, Lordship.
to respond. ಯಾವತ್ತಿದೆ exam?
ಅದು next month ಅಲ್ಲಿ ಏನಿದೆ approximately.
Issue emergent notice to the respond number 2, returnable by 3rd March. Counsel for the petitioner is also permitted to take out and summons
Please, Lordship.
on respond number 2.
Obliged, Lordship.
My lord, last occasion, my lord, maintainability regarding
Yes.
memo, my lord, one document.
ಕೊಡಿ.
Seven application rejected, my lord.
They have to file the appeal, Your Lordship, before the KIT.
7A ನೀವು ಫೈಲ್ ಮಾಡಿರೋದ? ರಾಮಚಂದ್ರ, ನಾರಾಯಣ್ ಭಟ್, ಸುರೇಶ್ ಸೋಮಪ್ಪ.
Respondent 6 to 7A ನಮ್ಮ ಪರವಾಗಿ ಅಪ್ಲೈ ಮಾಡಿದ್ರು.
ಯಾರು ಫೈಲ್ ಮಾಡಿದ್ರಿ 7A?
7A ನಮ್ಮ ಪರವಾಗಿ ದೇವಪ್ಪ.
ಬಸಪ್ಪ, ಶಿವನ ಬಸವರ್.
ಅದೇ ಅವ್ರಿಗೆ ಇವ್ರಿಗೆ ಏನ್ ರಿಲೇಷನ್ ಇದೆ ಅಂತ ಹೇಳಿ ಲಾಸ್ಟ್ ಟೈಮ್.
ಶಿವ ಬಸಣ್ಣವರ್.
ಹಾ.
ನೀವು ಅವರ್ ರಿಲೇಟೆಡ್ ಅವ್ರಿಗೆ?
ಇಲ್ಲ ಮೆಮೋ ಕೊಟ್ಟಿದ್ದೀನಿ, ಮೆಮೋದಲ್ಲಿ ಇದೆ. ಇಲ್ಲ.
Even the present petition is not maintained, Your Lordship. They have to file the appeal before the KIT.
ಅದೊಂದು. ಬಟ್
ಇಲ್ಲಿದೆ.
ಯಾರು ಇವರು ಅಂತ ನೀವು ಶಿವ ಬಸವಣ್ಣವರು ಹಾಕಿರೋದು ಅಪ್ಲಿಕೇಶನ್ 7A.
ಹೌದು.
ನೀವು
ಸಿದ್ಧ ಬಸನ್ನವರು.
ಸಿದ್ಧ ಬಸವಣ್ಣವರು.
ಹೌದು.
ಶಿವ ಬಸವಣ್ಣವರು ಸಿದ್ಧ ಬಸವಣ್ಣವರು ಸೇಮಾ?
ಫ್ಯಾಮಿಲಿ ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ ಅವರು. ಏನ್ ನನ್ನ ಮೆಮೋದಲ್ಲಿ ಇದೆ, ಪೇಜ್ ನಂಬರ್ 4 ಮೇಲೆ. The family of which I am a member hold the following the lands, my name and in
ಶಿವ ಬಸವಣ್ಣವರು ಅವರು
the names of family members. ಇಲ್ಲಿ ಎಲ್ಲ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ.
ಎಲ್ಲ ಸಿದ್ಧ ಬಸವಣ್ಣವರು ಇಬ್ರು ಇದ್ದಾರೆ. Yes. Now what are you challenging? Is challenging rejection.
Yeah, yes. They have to file the appeal, Your Lordship, before the KIT. 77A, Your Lordship. 118 under section 118, they have to file appeal before KIT.
ಯಾಕಪ್ಪ ಇಲ್ಲಿ ಬಂದ್ರಿ?
Annexure D, Your Lordship, is the order. Annexure A is the form of 7A, Your Lordship.
7A has been rejected.
Yes.
Learned AGA accepts notice for respond number 1 to 3. Notice to respond number 4 to 6 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. What is essentially challenged by the petitioners is the order passed by respond number 2, Additional Commissioner Administration Development, rejecting the Form 7A filed by the petitioner and their other family members. The petitioner has an alternative efficacious remedy in terms of appeal under section 118.
118.
118 of the Karnataka Land Reforms Act. Reserving such liberty, the petition stands disposed. All contentions are left open. ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು ನೀವು ತಿಳ್ಕೊಂಡು ಯಾವ್ದು ರಿಲೀಫ್ ಎಲ್ಲಿಗೆ ಬರಬೇಕು ಅಂತ ತಿಳ್ಕೊಳ್ಳಿ. ಎಲ್ಲದಕ್ಕೂ ರಿಟ್ ಪಿಟಿಷನ್ ಬರಲ್ಲ.
ಅಲ್ಲ ಪ್ರಾದೇಶಿಕ ಆಯುಕ್ತರು
ಅದಕ್ಕೆ ಎಲ್ಲ ಪ್ರಾದೇಶಿಕ ಆಯುಕ್ತರು ಅಂದ್ರೆ ಎಲ್ಲ ರಿಟ್ ಪಿಟಿಷನ್ ಬರಲ್ಲ. ನಿಮ್ಗೆ ಗೊತ್ತಾಗಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ ಸೀನಿಯರ್ಸ್ ಹತ್ರ ಕೇಳ್ಕೊಳ್ಬೇಕು. ಕೇಳ್ಕೊಂಡ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಮಾಡಿ.
Kindly, my lords, I'm extremely sorry, my lords. Seal number 43. I was not added, my lords. That's the reason I could not make submission.
In which matter, Mr. Srikanth?
Seal number 43, my lords. My lords, in
40?
fact, on the last occasion, my lords, your lordship permitted us to, my lords, to appear before the my lords first responded, as we raised a grievance that, my lord, during the
43.
pendency of this petition.
Just one moment, just one 43.
Please.
What is this IA 1 and 2?
My lords, one is, my lords, for extension, my lord, extending the.
We can't hear you very well, Mr. Srikanth. You'll have to speak closer to the mic.
My lords, one is for, my lords, renewal of recognition. The second one, my lords, is for permitting us to, my lords, to fill up the vacancies, my lord, which are there in the institution.
Yes.
My lords, the grantinate was withdrawn. The institution was ordered to be closed, which were challenged and interim orders are granted, my lord, by this honorable court.
Yes.
My lords, what is happening is they are not permitting us to, my lords, appoint the teachers and also not
Yes,
renewing
argue the matter on merits, please.
My lords, the contention what we have raised is, my lord, there is no
You are
complaints of
ready, Mr.
section.
Sulsumat, on merits?
We have already filed the statement of objection.
Are you ready for
Yes,
argument?
yes.
Yes, Mr. Srikanth.
In fact, my lord, considered orders were passed by this honorable court, while, my lord, considering inter-alia, it is specifically observed no procedure under section 53 is complied with. Your lordships may have, my lords, the writ petition, my lords, the second writ petition, my lords, 106758.
Yes.
My lord, just to give, my lords, history, my lords, there was an order, my lords, passed withdrawing, my lords, the grantinate came to be challenged before this honorable court. In the meanwhile, my lords, we also said we'll provide infrastructure, my lord, that was also provided. This honorable court said we can make a representation and that will be
So you
considered.
have not been given an opportunity of hearing, is what you are
Section
contending.
53 contemplates for an inquiry which is not done. Is what, my lord,
What has not been done?
Section 53 of the Karnataka Education Act provides for, my lords, holding of an inquiry. No inquiry is conducted.
The Education Act. Is Mr. Kalsurmat, has the inquiry been conducted?
My lord, in this case,
They conduct, my lord, inspection. My lords, no inquiry is conducted. My lord, inspection is different.
Mr. Srikanth, are you Mr. Kalsurmat?
No, I am sorry, my lord.
Yes.
Lord, as per the statute itself, inspection was conducted and deficiency. Inquiry is not done. Inspection has been conducted.
Inspection cannot replace inquiry.
Yes, that cannot be. But in the year 2008 itself, my lord, their granting aid was cancelled. Agreed by that, my lord, a writ petition was filed before this honorable court.
2018 it has been
Oh,
cancelled.
2008. Original order which has been. The paginations are not correct, my lord.
7/11/23 is challenged.
Lord, in this case,
ಯಾವಾಗ grantinate cancel ಯಾವಾಗ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ ಅದು correct documentation and pagination is not properly done.
If your lordships are having 105966, my lords.
105966.
Yes. In that, my lords, page number 122.
122.
121, my lord, the order starts. Annexure Z. 122, my lords, is the relevant page, my lords. Annexure Z, my lords. 121 last paragraph, we claim that we have provided infrastructure, but not, my lords, they don't, my lords, do any exercise to find out the veracity of, my lords, that statement made.
Who has to conduct the inquiry?
Not the government, my lords.
The state government may after such inquiry. So state government andre yaro illi?
Principal
Who is the
secretary,
government?
first respondent.
State government is the deputy director of public instructions or the
No,
commissioner?
Not the principal
Commissioner.
secretary to government.
Commissioner.
Secretary to government, not commissioner is not government. Not he comes under not section 7 authorities of not under the act. Not the government means not the secretary first respondent.
Why would all these inquiries have to go to the secretary, Mr.?
Unless and until it is delegated, statutory provisions also cannot be delegated, such as inquiry that is to be done by the government itself.
A lot of.
Yeah, state government andre yaru, Mr. Kalsurma?
Well, state government andre it is invariably the the principal
Has there
secretary.
been any delegation?
No delegation. The delegation is also not permissible, is my submission.
So we'll remit it to the first respondent.
Yes, Mr.
In a time-bound manner, let him conduct the inquiry.
Please.
In 30 days, he'll finish the inquiry. We'll direct the petitioner to cooperate by providing all the necessary documents.
Please.
Once the inquiry is done, under 53, they'll have to be heard.
Heard, yes.
Hear them and pass orders.
Yes, Mr.
Yes. Why should this be? This could have happened.
Allah, we are pressing for that, my lord. One or the other way, they are. That is going on.
The order was
Lord,
stayed.
Now you got 2 years of stay here. Now let it all get over in 2 months.
No, in the second petition also they passed similar order. That is also question. When the first petition was pending.
The petitioner is the Dharwad district Veer Rani Kittur Channamma Shikshan Sanstha running a school in Kalgatgi. Please. The petitioner is before this court in both the above petitions seeking for the following reliefs. The only grievance made out by the petitioner is that the grant in aid which had been made available to the petitioner school has been cancelled without holding an inquiry under section 53 of the Karnataka Education Act 1983.
Please.
And as such, the same.
Further, they ask us to close the institution.
And as such, the same is not maintainable.
Please.
Learned AGA submit that an inspection of the school was conducted when it was found that many of the requirements were not satisfied.
Yes.
And it is on that basis that the grant in aid was cancelled. Heard so and so peruse papers. Heard Shri MP Srikanth, learned counsel for the petitioner, Shri V.S. Kalsurma, learned AGA. Section 53 is reproduced of the Education Act is reproduced hereunder for easy reference. A perusal of the above provision would indicate that the state government can withhold, reduce or withdraw the grant made after such inquiry as it deems fit and after giving an opportunity to the governing council of the institution concerned of making a representation against such withholding, reduction or withdrawal. In the present case, what has been done is only an inspection of the school when certain deficiencies were found. In furtherance of said inspection, an inquiry also ought to have been conducted, and the inquiry report furnished to the petitioner to enable the petitioner to submit why, in furtherance of such report, the withholding, reduction or withdrawal could not be made. the holding of an inquiry and providing an opportunity to the governing council to make a representation against the proposal of withholding, reduction, or withdrawal, being a condition precedent for passing an order of withholding, reduction, or withdrawal. I am of the considered opinion that the same not having been complied with, the impugned orders passed by the state suffer from legal infirmity requiring this court's intervention. Liberty is would also writ petition allowed, so on and so forth. Liberty is reserved to the state government to conduct an inquiry as regards the working and the facilities.
One submission before. Lord, along with the statement of objections, inspection was conducted on 30th/5/2023 in the presence of the petitioners, and after having furnished the documents and everything, we have passed an detailed inquiry report.
Inquiry report?
Along with photographs and ಇಲ್ಲಿದೆ ಮಾಡಿದ್ದೇವೆ ಎಲ್ಲ ಮಾಡಿದ್ದೇವೆ
inspection
ಅದೇ
inquiry report.
ಅಲ್ಲ, the present petitioner was also present at the time and he submitted.
Would require you to record statements,
please. Yes,
including the statement of their headmistress or headmaster,
please,
lab technicians, ಅವರು ಇವರು ಎಲ್ಲ administration ಎಲ್ಲ record ಮಾಡ್ಬಿಟ್ಟು close ಮಾಡಿ. Liberty is reserved to the state government to conduct an inquiry in terms of section 53 of the Karnataka Education Act 1983, provide a copy of the inquiry report to the petitioner, affording an opportunity to petitioner to make a representation against such report, and thereafter pass necessary orders. The petitioner shall cooperate with the inquiry and provide all such documents, material and details as may be requested during the course of inquiry without demur. In the event of the petitioner not furnishing the documents, the petitioner would not be entitled to claim any equities. The inquiry to be completed, to be commenced from 24th February and completed by 24th March.
Please.
Your Lordship may indicate at 2:30 my lords will appear before the my lords, the principal secretary, so that my lord the
No, they will issue, they'll conduct the inquiry and they'll tell you what to do. After that, you submit a representation.
No, your lordships indicated 24th as the date, my lords. Will appear on 24th at 2:30, my lords, so that
You don't need to appear. They will start the inquiry. They'll come to your institution.
Please.
What will you do going to the principal secretary's office? You'll take the school along with you?
No, he never presents, my lords, which they say, my lord, have any document.
They obviously have to come to your school, Mr. Srikanth.
Please, please.
First respondent has to respond number 1.
Respond number 1.
Lordship, within 1 week, I will.
Counsel for the petitioner seeks fund is granted a week's time to make payment of necessary process fee in respect of respond number 6. If needful is done, registry is if needful is done by
24th.
24th, registry is direct. Issue notice to respond number 6, returnable by 29th April. If needful is not done by 24th February, released on 28th February for dismissal. Accepting the reasons stated in support of IA1 of 24, the production certified copy of Annexure E is dispensed with.
Please. Para number 8, your lordship of the petition. That your lordship, the respondent number 3 ought to have considered that original owner of land so and so, Mulimani Neelam has expired on 16/9/79, and in person death of Mulimani, petitioner and others being the last. Only because the other last they are not made the parties. Tomorrow they may come.
You have to come on record.
So, no, my lord. Mulimani Neelamma is the daughter-in-law of that deceased, my lord.
Your petitioner is the daughter-in-law of Mulimani Neelamma.
Neelamma. Only husband is there, my lord.
You should have filed an application to come on record. They can't come and search for you.
Please. Okay, we'll bring them on record.
Because their main condition that without hearing them, it is their main condition. They have not made the other legal.
Annexure E ಯಾರು ಪಾಸ್ ಮಾಡಿರೋದು?
Tahsildar of respondent number 4, my lord. Respondent number 3.
Who is respondent number 6?
6 is the beneficiary of the orders passed by respondent number 3.
He has to be served.
Because their condition that, your lordship, petitioners are not heard, but they are saying that other legal representatives.
Even to reserve
Tomorrow
liberty,
they may come, your lordship.
liberty reserve ಮಾಡಿ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಕ್ಕೂ respondent number 6 ಸರ್ವ್ ಆಗ್ಬೇಕಲ್ಲ. Written by so and so.
My lord, with your kind permission, I have one submission to make. In serial number 28, my lord, interim order is there. Kindly be extended, my lord.
28 interim order.
Please.
The last occasion, my lords, this is a matter, my lords, where there is a sale deed, and in spite of it, my lords, they are claiming upon the will, my lords, and the order of the deputy commissioner is under challenge. On the last occasion, my learned friend was pleased to raise an objection, my lords, with regard to presence of the thumb impression, my lords, of the original owner on the sale deed. If my lords could kindly see, my lords.
Page.
My lords, page annexure A, my lords.
I'm sorry, my lords.
Annexure
Just, I'm sorry, my lord. Just now they have given me the typed copy
I
of
have already
sale deed.
produced that copy, my lords. Typed copy I have furnished, my lords. It's not that for the first time I am producing any document as such.
I request it to kindly be taken on Monday, my lord.
No, my lords. They are trying, my lords, hard to then let there be an interim order, my lords. Then, my lords, they can.
Please, my lords, kindly please look into the order sheet, my lords. We have produced.
Lords, the first instance, let me
ಏನ್
establish.
ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅವರು? What are they doing?
Now they are affecting Podis, my lords. They want to divide my property now.
Don't do anything till then.
Yes.
If you are seeking for adjournment.
No, my lords, but kindly please look into the observation of the trial code, my lord. Trial code,
If
my
you
lord.
want to argue, please argue. If you want time, then don't do anything until you argue. So we'll stay it until then.
Fine.
ಇವಾಗ argument
Till
ಮಾಡ್ತೀರಾ
Monday.
ಏನು?
Yes, ma'am. Monday, my lords.
Monday.
Monday.
The operation of the order dated 27/6/24 in RA number so and so at annexure G is stayed till the next date of hearing. At the request of counsel for respond number 9, relist on 17th.
17th. 18th or 19th.
ನೀವಿಲ್ವಾ 17th 18th? ಎಷ್ಟು ಜನ ಇಲ್ಲ? ಎಲ್ಲ ಗುರುದೇವ್ ಗಚ್ಚಿನ ಪೆಟಿಷನರ್ ಲಿಸ್ಟ್ ಮಾಡಿ ಡಿಸ್ಮಿಸ್.
19th.
AP ಹೆಗಡೆ ನಗ್ತಾ ಇದ್ದಾರೆ, ಅವ್ರದ್ದು ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಮಾಡಿ. 19th.
Great. Same lords. 41 and 41 point same model. Interim same lords in all three matters.
Yes.
Great.
My lord, office objection at serial number 19 is that all parties to the land tribunal order are not made parties. Lordship, may kindly turn to page 32, annexure E. This is the impugned order. My lord,
regards various survey numbers.
My lord, it's a very peculiar case. With respect to 10 survey numbers, the proceeding is there. But land tribunal has passed this impugned order only with respect to one survey number. That is serial number 2, that is 639/1B. For this, my lord, only 2 persons had filed form number 7.
That counsel for the petitioner submits that what is impugned is the order passed as regards survey number 639/1B.
Yes.
And the parties in respect to said survey number have been made parties to the present petition, and the others have not been made parties. Accepting his submission, office objection at serial number 19, he is overruled. Yes.
My lord, the impugned order is passed with 639/1B. My lord, the fathers of petitioners, who are 2 brothers, they jointly filed form number 7 with respect to this 639/1B at annexure A. And the predecessor of respond number 5, by name Mahabaleshwar Shankar Bhatt,
been rejected.
Yes, my application is not considered. My application is not considered. His application is rejected midway the proceedings, and he is held to be the landlord. He is held to be the landlord and his name is ordered to be entered. Even though he himself has filed in form number 7, admits that respondent number 4 is the landlord. A very strange order, my lord. With respect to other 9 server numbers, the proceeding is still there.
And AG accepts notice for respondent number 1 to 3, issue notice to respondent number 4 and 5, emergent notice to 4 and 5, returnable by 17th April. The operation execution of the order passed by respondent number 2 in LRT so and so dated 10/3/23 at Annex E is stayed till the next date of
Yes,
hearing.
Lords, with respect to respondent number 10, my lords, the petitioner number 11, respondent number 11 to 17, and I'll file the memo with respect to. I'll file memo.
Counsel for the petitioner submit that respondent number 11.
Petitioner number 11 and respondent number 11 to 17 and respondent number 19.
Petition number 11, R11 to 17.
And R19.
19.
Are the legal heirs who are already on the record.
Of 10.
Yes, please.
What about 20?
Yeah, I'll take, my lords. I'll take steps.
The counsel for the petitioner has filed a memo stating that the legal representatives of deceased respondent number 10 are already on record. They being petition number 11, respondent number 11 to 17 and 19. Accepting the said submission and said memo and submission of counsel for the petitioner. Petition number 11, respondent number 11 to 17 and 19 are treated as legal representative of deceased respondent number 10. Counsel for the petitioner to carry out necessary endorsement in the cause title.
Please.
Counsel for the petitioner seeks for and is granted 2 weeks time. Please to file necessary application to bring the legal representative of deceased respondent number 20 on record, as also to make payment of necessary process fee in respect of the other unserved respondents.
I undertake to appear on behalf of respondent number 15 and 16.
Process fee better. She so and so submit that you would be appearing for respondent number 15 and 16. Registry is directed to print his name as such. Hence, there would not be any requirement for the petitioner to make payment of any process fee in respect of the said respondent. If the application to bring the legal representative of deceased respondent number is not filed by 28 February, the petition would have to be formally dismissed against respondent number 20. Relist on 14th March.
In this matter, I appear for respondent number 1 to 6.
Yavrali.
I filed an application for vacating the interim order. Suit proceedings stay in the RA, so this honorable court has granted an interim order. By not staying the suit, judgment and decree passed in the suit.
Judgment
This
decree.
is a suit for partition and separate possession.
Judgment and decree has been stated.
Judgment and decree stayed.
The impugn
WP.
I understand, my lord. So if the FDP proceedings for the drawing up of final decree is stayed, my lord, then it's, I can understand. But
the impugn order is, my lord, during the first appeal. The impugn order is during the first appeal, my lord. The petitioner has filed an application for stay of the judgment as well as a delay.
The order dated 5/7 in RA on IA2.
Please.
Yes, my lord.
That was for the condemnation of delay.
There was an application seeking condemnation of delay. That was not considered.
Only on that basis that application can to be dismissed.
IA2 for condemnation for
IA1
stay is
IA1 is for condemnation of delay.
IA2 is for stay.
IA2 is dismissed.
Yeah, no, my lord.
Yes, yes, it is
Please.
It is rejected. IA2.
Stay is dismissed.
Please.
Condemnation of delay dismiss agide.
Only on that basis, my lord, since there is a delay application is pending, the trial court has assigned the reason saying that, my lord, since IA is pending, so this application cannot be considered. Understand?
So now notice has been ordered. Appeal is still pending.
Appeal is pending. This honorable court has, my lords, granted an interim order staying the proceedings.
Staying the proceedings in RA.
Proceedings in the under judgment and decree.
Judgment and operation of the
Operation of judgment.
judgment.
That is being stayed now.
Add interim order as prayed for. What is prayed for?
In page 19.
So 41 Rule 5 has been allowed by this court.
Yes, yes, that is. Interim
Yes.
order is granted.
Ah.
By staying, my lords, the further proceedings in the judgment and decree.
Correct, since the appeal is pending.
Appeal is pending. Can understand, my lords. If the FDP is filed, my lords, and the further drawing up of FDP is not stayed, till then, my lords, the proceedings have to be continued.
The order which has been passed is akin to one under Rule 5 of Order 41,
Yes,
staying the operation of judgment and decree.
without, my lords, considering the application for condemnation of delay. That has to
Because
be
that is
considered.
pending. ಇವಾಗ RA ಏನಾಯ್ತು?
That is pending.
What is
RA
happening?
RA is also pending.
RA is pending.
So you argue the matter there. If the limitation application, condemnation of limitation application is dismissed, then you can come and say the appeal will go, this petition will go. If the limitation is allowed, condemnation is allowed, then the judgment will have to be stayed. Otherwise, there won't be a purpose in the appeal being there.
Yes, my lords, but insofar as, my lords, at least since it is a suit for partition and separate possession, they are also claiming a share, my lords. Let the FDP proceedings may go on. And, my lords, at the.
FDP ಅಲ್ಲಪ್ಪ RA ಇದೆ.
RA then. OS judgment has been stayed. We have filed FDP. And if, my lords, the drawing up of final decree is stayed, still then, my lords, the proceedings may have to be continued. That is what.
My lords, with respect to that, my lords, the counsel on record is my friend. He's not well. I request.
He had been to Prayagraj.
Notice ಆಗಿ ಬರ್ಲಿ.
Please. Interim order need to be extended.
Interim order ಅಲ್ಲಿ
Therefore.
Application may be, registry may be direct to put up my application. Application for vacating.
Counsel for respond number 1 to 6 submit that he has filed an application for vacating. Registry is direct put up the same.
It may, I'm sorry, my lord, it may take next week, your lordship. There might be some communication gap, your lord, from our side.
ನಿಮ್ಮಿಂದನಾ?
Direction was disposed of matter, my lord, wherein direction was issued.
ನಿಮ್ಗೇನಿಲ್ಲ.
ಅವ್ರದ್ದೇ.
ಅವ್ರಿಗೆ. $38A. And AGA seeks for and is granted a week's time to place on record the compliance report. We list on 21st February.
Appearing for the petitioner, my lord, writ of mandamus, my lord. And seeking early disposal of the OS number 178 of 2007, my lord.
Early disposal ಅಂಕ್ ಹೇಳಕ್ಕಾಗಲ್ಲ. Why?
Since 2007 matter.
ಏನಿದೆ ಸ್ಟೇಜ್ ಇವಾಗ?
My lord,
What is the stage of the suit?
for hearing it is there. my lord.
For final argument.
Yes.
Stage ಏನು? CRP, writ petition ಎಲ್ಲ ಹಾಕೊಂಡು ಸ್ಟೇ ಎಲ್ಲ ಆಗಿ ಬಂದಿದೆ.
Yes,
You can't find fault. Final argument ಇದೆ.
ಇಲ್ಲ, my lord. Hearing on A, my lord.
Hearing in IA is pending, my lord.
Notice to the respondents is dispensed with renewal of the proposed order to be passed. The petitioner is before this court seeking for the following leaves. The grievance of the petitioner is that suit of the year 2007 is still pending consideration before the trial court and has not been dealt with the expediency that is required. On the basis of said submission, a mandamus cannot be issued as sought for. The trial court, seized of OS number 178 of 2007, would be well advised to dispose of the matter at the earliest, since the suit has been pending for last 18 years. All Bengaluru ಹೋಗಿದಾರಾ? Reporting compliance, ಇವ್ರಿಗೆ. ನಿಮ್ಮ ಕಂಪ್ಲೈನ್ಸ್ ಸಂಗಮಗೌಡ ಎಲ್ಲರಿಗೂ ಇನ್ಫಾರ್ಮ್ ಮಾಡಬೇಕು, PDO ಹೇಳ್ಬೇಕು ಸೈನ್ ಮಾಡಬೇಡ, ಸೀಲ್ ಹಾಕ್ಬೇಡ ಅಂತ.
Just pass consultative lordship.
ಪಾಸು.
My lord, I appear for respondent number 10.
Yes, Mr. Raghavan.
In serial number 54.1, my lord.
Yes.
Acquisition of the year 1971 is thought to be challenged. And today, my lord, there is a investment of 90,000 crores and the factory has come up. We are an integrated steel plant, largest in Asia. And these petitioners, my lord, who have no locus, we don't know who they are. They just come and challenge the entire acquisition which was made in 1971. My lord, JSW Steel, my lord, is a plant that has been running now for the last several decades. And interestingly, my lord, these petitioners have taken ex gratia payment from us. And they have suppressed that fact before this honorable court.
Yes.
My lord, appearing for petitioner, my lord. CL number 54, my lord. That the three objections are there, my lord. CL number 52, passing authority. Earlier it was a government of Mysore, my lord, revenue department. Now it is a state of Karnataka.
In fact, in 54, no notice are been issued.
In 54, no notice has been issued, my lord. 54.1, I appear for respondent number 10. In fact, notice has not been ordered in 54.
Accepting the submission of counsel for the petitioner, office objection at CL number 52, 53 and 54 are overruled. Accepting the submission of the counsel for the petitioner, legible copies. Legible copies we won't. Yes, 54.1N.
Yeah, my lord. Post it for March first week, my lord. My senior will argue the matter. We are engaged the senior counsel, my lord.
So if you are engaged as senior counsel, you have to be here. We are not concerned with your senior counsel coming or not. There is another senior counsel already here.
Yes, my lord. It's my humble submission because that 50.
Not a ground for seeking for an adjournment.
Last two occasions they took adjournment. Last two occasions they took an adjournment because
No, my
court
lord.
has asked.
No, due to the.
But there is a difficulty, my lord, for us. The very pendency of this writ petition, these frivolous writ petitions, my lord, comes in the way of the progress
We
of
are
the
not
company.
taking
We are a listed company. And these litigations, my lord, come in the way of further investment, further progress. And it is against public interest, my lord, to even keep these petitions pending before this honorable court is my respectful submission. And acquisition of 1971 is thought to be challenged in 2024. After 53 years.
My lord, acquired for the public purpose, utilized for the private purpose, my lord.
But that's on merits, my lord. I will, if that's on merits, I will show to your lordship that even that is frivolous. And the law is very clear on that also. But 1971 acquisition, whatever may be the grounds.
Monday, keep him present. If you don't argue, we'll dismiss it.
My lord.
Can't be asking for time.
At least a
My
week's
lord,
time.
can it be on 20th, my lord? I will come personally for this matter.
May I make submission? ASG is coming 20th, my lords.
ASG is coming.
ASG is coming.
Dismiss ಮಾಡಕ್ಕೆ ASG ಏನಕ್ಕೆ ಕರಿಬೇಕು? ಆಯ್ತು ಕರ್ಕೊಂಡು ಬನ್ನಿ.
20th.
What about 54? ಅದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಕೊಟ್ಬಿಡೋಣ.
No, my lord, your lordship may even not issue notice in 54.
Same
my lord.
connected.
Whatever happens in 54.1 will happen to 54.
Yes, formally notice will be there so that Sri Venkatesh Karvi accepts
Name of
notice for
Muttunjay Hallikeri. KVET file ಮಾಡಿದೆ. Muttunjay Hallikeri.
ಎಲ್ಲಿದೆ ಮುತ್ತುಂಜಿ ಹಳ್ಳಿಕರಿ? ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ ಯಾರು? ಹಳ್ಳಿಕೇರಿನಾ ನೀವಾ?
54.
54. Sri Venkatesh Karvi accepts notice for respond number 1 and 2. Learned AGA accepts notice for respond number 3 to 8. PNRT for respond number Shashank Hegde for respond number 9. Sri Prashant Gowder for respond number 10. 11 arrow. Pollution Control Board. Sri Raviraj C. Patil for respond number 11. 12 Mysore Mineral Corporation.
My lord, if I may submit, my lord, all these parties are unnecessary for the purpose of adjudication.
We'll complete the procedure, Mr. Raghavan, so that it's not.
My lord, they'll come and tomorrow say we want to file objections and this will drag on, my lord. That's the only anxiety I have.
Who is the standing counsel for Mysore Mineral? Counsel for the petitioner is directed to take out hand summons on respond number 12. Learned AGA is also directed to inform respond number 12 about the above proceedings to enable respond number 12 to appoint a counsel. 54.1 Kodi.
Complete ಆಗಿದೆ. Their service of notice is completed.
Notice.
ಗೊತ್ತಿಲ್ಲ ನೋಡೋಣ ಇರ್ರಿ. 54.1 Venkatesh Karvi for 1 and 2. 3 to 8 AGA. Shashank 9. Prashant Gowda 10. Is complete.
And they have not filed any statement, my lord, on this 54.1.
54.1.
Challenging 1971 notification, Mr. Counsel.
Yeah, my lord. Recently they have made a sale date, my lord. September. Last September only.
Can you challenge a 71 notification? We were not born, probably you were also not born at that time. Only Mr. Raghavan might have.
I was born, my lord. But I was not a lawyer.
All of you who are standing here were not born at that time.
But I was not a lawyer, my lord.
On the face of it, it is not made. You can't challenge 71 notification now. And who are you? You are not even a landowner.
Exactly.
No, we are the landowners, my lord.
You are the landowner.
Earlier we
No,
are
no. My learned is wrong. My learned is wrong.
If you are not a landowner, you will have to go as a public interest litigation. It's not a private interest. And because you are saying you are getting senior counsel, we are giving you time. Otherwise, you would have dismissed it right away. 71 though. And please inform the senior counsel also that there may be heavy cost which may be imposed for 54 years delay. Since you have the money to engage a senior counsel, you have the money to pay costs. So, ನೀವು ಇದ್ದಾಗ ಬೇಡ, ಅವ್ರು ಇದ್ದಾಗ will impose it. 54 yearsಗೆ ಒಂದೊಂದು ವರ್ಷಕ್ಕೆ ಎಷ್ಟು ಲಕ್ಷ ಅಂತ ಹೇಳ್ಕೊಂಡು ಬನ್ನಿ. Not thousands or hundreds.
20th, my lord.
20th.
Great.
And for respond number 3, your lordship. And for respond number 3, short accommodation to file an objection, your lordship.
ಸರ್ ಅದೇ ಪರ್ಸನಲ್ ಅವರಿಗೆ ಸಮನ್ ಸರ್ವ್ ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರು ಸರ್, ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್.
43(1) ಏನಿದು ಅಬ್ಜೆಕ್ಷನ್?
ಸರ್ ಐ ಹ್ಯಾವ್ ಒನ್ ಸಬ್ಮಿಷನ್, ಮೈ ಲಾರ್ಡ್ಶಿಪ್.
ಇನ್ನ ಅಫಿಡವಿಟ್ ಸ್ವೇರ್ ಆಗಿಲ್ವಾ?
28th ಕಂಪ್ಲೈ ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರು ಸರ್, ಕಂಪ್ಲೈ ಮಾಡಿದೆ. ಬಟ್ ಅವರು
ಯಾವುದೂ ಕಂಪ್ಲೈ ಆಗಿಲ್ಲ. None of them has been shown to. Counsel for respond number 364 and is granted 2 weeks time to file a statement of objection. Counsel for the petitioner is also granted 2 weeks time to comply with the remaining office objection. If the office objection is not complied by next date, petitioner will be liable
one
to dismiss
submission,
for
my lordship.
non-prosecution. Field list on 14th March.
At the same date, 28/1/2025, the Neregal Patal Panchayati officers vacant my premises, sir.
Vacate ಮಾಡಿದ.
Yes, sir.
But you will have to ask for.
Yes, sir. ಅದೇ ಹ್ಯಾಂಡ್ ಸಮ್ಮನ್ಸ್ ಕೊಟ್ಟು ಡೇನೆ ನನ್ನ ಪ್ರಿಮೈಸಸ್ ಎಲ್ಲ ವೆಕೇಟ್ ಮಾಡಿದ್ದಾರೆ.
ಮತ್ತೆ ಇವಾಗ ಏನು ಅಮೆಂಡ್ಮೆಂಟ್ ಫೈಲ್ ಮಾಡ್ಬೇಕಲ್ಲ?
ನೆಕ್ಸ್ಟ್ ಡೇಟ್
ಇದರ್ ಕಂಟೆಂಪ್ಟ್ ಹಾಕ್ಬೇಕು ಇಲ್ಲ ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕ್ಬೇಕು.
ಪ್ಲೀಸ್ ಸರ್.
ಹಾಕಿ ನಾವು ಅಡ್ವೈಸ್ ಮಾಡಕ್ ಆಗಲ್ಲ ನಿಮ್ಗೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ.
ಪ್ಲೀಸ್ ಸರ್.
ಅವ್ರು ಆರಾಮಾಗಿರ್ತಾರೆ.
In that interim order may kindly be extended. Serum 55.
55 interim order earlier granted is extended till next day. 56. Yes, Mr. Mehta.
My lord, it is plaintiffs are the petitioners.
Yen 27 and 53.
My lord, regarding eligible copy of Annexure A and removal of markings in impugned orders, my lord, it is marked in the certified copy itself.
Accepting the submission of counsel for the petitioner, office objection
Lordship.
serial number 27 and 53 are overruled. Yes.
My lord, it's a petitioner's case is that, my lord, they sought for a declaration and easement of necessity to reach their lands, my lord. Hand sketch is mapped in the page number.
So it's a confirmatory order.
Please, my lord.
Your injunction application was
It is rejected by
rejected
trial
and
court, and it is
confirmed by the High Court.
First appellate
First
court.
appellate court. Yes.
My lord, we are the landowners.
Ready, where's your plaint?
My lord, plaint is page number 13, my lord. Sketch is on 22, my lord, page number.
22.
My lord, we used to, my lord, this is Ranebennur Irony Road, this is. We are the landowners of this, now so many lands were there, my lord.
ನಿಮ್ದು ಯಾವುದು?
My lord, the petitioners are the landowners of this, which have been marked, my lord, all these pieces of land ಇದೆಯಲ್ಲ, ಈ landowners ಇದಾರೆ. We used to ingress it at a point A and B, and we used to write the arrow marks we have seen to reach to our land, my lord, since more than 60 to 70 years. This petitioner number 1 purchased the property in the year 2000.
Which property you purchased?
My lord, the petitioner, respondent number 1 purchased the property in 2004.
ಯಾವ survey number?
252/1.
252/1. Yes.
And defendant number 2 purchased the property 253/4. This is on the other side, my lord.
Yes.
In the year 1993. They did not observe. We used to pass through these land, my lord, since many years. Till 2023, my lord, they have these petitioners, these defendants did not object for me to use that land to reach our land. In the year 2.
You are the owner of?
My lord, this all the petitioner, all these lands, my lord.
All these ಅಂದ್ರೆ ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಹೇಳಿ?
My lord, just a minute.
Are you the owner of 255?
17 survey numbers are there, my lord. 17 survey numbers we are the
So
owners.
which is the first survey number you own?
252 2AA.
252
2AA.
Okay, that is below 252/1.
Please, my lord. Next 252 2B/1.
Adella, they are not related to defend number 1 and 2.
They are not related to defend.
Only this portion in the top
My lord.
is what is the subject matter of the
Subject
litigation.
matter of it.
The rest of it is all between you as
There is no
the petitioners, plaintiffs.
blockade by any other persons, my lord.
Yes.
In the year 2004, my lord, the defendant number 2 purchased the property. Thereafter, my lord, they started to cause obstruction by digging the trenches by using earth movers. So we may try to mediation, my lord, they did not heed to
What is the extent of this passage?
My lord, 10 feet for agricultural purpose.
10 feet by? What is the length?
Length, gottilla. It is a cart road, my lord, that much I can.
From B to L,
A
what is
to
the length?
A and B to C, K and L ವರ್ಗೂ ಅವ್ರು ನಮಗೆ ಅಬ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ್ತಿರೋದು.
A to K ಆಮೇಲೆ B to L ವರ್ಗೂ ಎಷ್ಟು ಡಿಸ್ಟೆನ್ಸ್ ಎಷ್ಟಿದೆ?
ಕರೆಕ್ಟ್ ಅವರು ಹೇಳಿಲ್ಲ.
ಅಪ್ರಾಕ್ಸಿಮೇಟ್ಲಿ ಎಷ್ಟಿರ್ಬೋದು?
ಒಂದು 40 to 50 feet ಇರ್ಬೋದು ಅನ್ಕೊಳ್ತೀನಿ, ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಇರ್ಬೋದು.
Speaking of around 400 to 500 feet.
ಇರ್ಬೋದು.
You are ready to purchase? Are you ready to ಇಷ್ಟು ಜನ ಇದ್ದೀರಾ?
That it is the only road, my lord, there is no other road also there.
My contention is that they have alternate road, and another suit OS 44 to 2020, my lords, was filed, and in that suit it is held that they have alternate road which is on the eastern side of the boundaries of these lands, my lords. My lords may kindly see page number 51 of the order.
Paragraph 8, my lord.
Paragraph.
Both the courts finds that, my lord, there is an existence of the marks of the road, but they say that it's a tribal issue whether there is an alternative way or not.
Was a commissioner appointed?
No, commissioner is not appointed.
We'll appoint the ADL.
My lord, two documents which I refer to. My lord, Annexer L. It is a 19.
Smith, we'll appoint the ADLR to see and find out if there are roads.
One more, my lord, since last 2 years we are unable to contact. And Raita Samparka Setve and government has sanctioned to make this land. The trial court and first appellate court says that, okay, Indirama, it's the defendant number 1. But the survey numbers has not been mentioned. That's why we will not accept your contention.
So that is to be made by which authority, that road?
Government, my lord.
Yav authority?
Gram Panchayat.
Gram Panchayat.
My lord, Annexer K.
Yav Gram Panchayat adu?
Irony, my lord. Grama Panchayati Karale, Irony. Page number 104, my lord. Type of the copy is on 105.
The dispute in the above matter is as regards an access to the lands of the petitioners from the land of the respondent. The petitioners claiming that they have easement of necessity on account of there being no other access to their lands, whereas the counsel for respondent would submit that the petitioners have an access from another road, and as such there is no easement of necessity which could be claimed by the petitioners. In that view of the matter, and the considered opinion that the jurisdiction ADLR would be required to be appointed as a court commissioner to inspect the land subject matter of the above suit, to inspect the subject suit, to prepare a sketch of the respective lands of the petitioners and the respondents, demarcate the access to each of the properties of the petitioners and the respondents.
ಇಲ್ಲ ಅವ್ರಿಗೇನಿಲ್ಲ ಅವರೇ
ಅವ್ರದ್ದು ಮಾರ್ಕ್ ಆಗೋಗ್ಲಿ.
ಇಲ್ಲ ಅವ್ರಿಗೆ
ಮೇನ್ ರೋಡ್ ಇದೆ,
ಮೇನ್ ರೋಡ್
ಮಾರ್ಕ್ ಆಗಲಿ and submit a report in relation thereto. The ADLR would also have to ascertain from the jurisdiction Gram Panchayat if there is any proposed road to be formed in respect of any of the aforesaid, in respect of over the property of either the petitioner or the respondents. The inspection shall be conducted by the ADLR commencing from 10:30 AM on 21st February 2025. Since the order is passed in the presence of both the petitioners, petitioner counsel and the respondent counsel, there would be no requirement for issuance of any further notice by the ADLR to either the petitioners or the respondents. The petitioners and respondents can participate in the said survey, if they so choose fit, in the event of them not participating in the survey, they would not be entitled to claim any equities. Report to be filed on or before 27th February, relist on 28th February.
One more submission, Lords. And also ADLR should ascertain whether there exists any other alternate road for the.
All accesses and access to each of the properties. One the property in the next property, or they will have to sort it out. ಕೆಳಗಡೆ ಒಂದಕ್ಕೆ ಎಕ್ಸೆಸ್ ಇದ್ರೆ ಪಕ್ಕದವರು ಕೊಡ್ತಾ ಹೋಗ್ಬೇಕು ಅವರೇ, ನಿಮಗೆ ಬರಕ್ಕಾಗಲ್ಲ. ಅದಕ್ಕೆ ಈಚ್ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟೀಸ್ ಅಂತ ಹೇಳಿ.
Annexure A itself shows that Raita Samparka Sabhe. Let's get rest. And both the courts find
Registry is directed to print the name of learned AGA in the cause list. So to enable the AGA to file the report of the ADLR, the learned AGA to communicate the above order to the ADLR.
We have to present on 21st.
27th.
21st report inspection.
Inspection is on 21st.
Relist on 28th. Non-compliance.
Petition copy.
Compliance. A week's time is granted to the counsel for the petitioner to comply with the office objection. If not complied by 24th, relist on 27th for dismissal.
Please.
My Lord, made a submission, my Lord. I'll produce the legible copy of annexure A and B during the course of hearing of this petition. And serial number 7 is with regard to the payment of court fee. I paid the court.
We produced during the final hearing.
No, during the next statement. Next state I will produce.
You'll produce madidira?
Yeah, I will produce. Annexure A and B are the land tribunal order and the form 10 application of the petitioner.
A and B.
Yes, my Lord.
ಏನು ಕಾಣಿಸಲ್ಲಪ್ಪ.
My Lord, kindly see annexure C and D. Annexure C and D are the entries standing in the name of the petitioner for the property.
That is also not legible.
No, that is like, I produced a type copy, my Lord.
Either type copy.
Yes, type copy. But
A will require, alva?
yes, my Lord.
A and B.
A and B I'll produce.
Can't read anything. Everything is smudged.
The first serial number.
Type ಮಾಡಿ Monday ಕೊಡಿ.
My Lord, there is some urgency, my Lord, in this matter.
ಬೆಳಗಿಂದ ಟೈಪ್ ಮಾಡಿಸ್ಕೊಂಡು ಬರ್ಬೋದಾಗಿತ್ತಾ ಅರ್ಜೆನ್ಸಿ ಅಂದ್ರೆ?
My Lord, my land is being acquired without issuing any notification.
Land is
acquired, and now they are constructing road over my property. Kindly.
You will get compensation.
No, that is, they have not issued any notification, my Lord. Illegally they have acquired my land.
By whom?
By KRIDL, Karnataka Rural Infrastructure Development Limited.
Please, there is no standing counsel in so far.
And they are constructing a road over my.
Issue notice to respond number 1 returnable by 12th March. PDO Agragon. 1 and 2 returnable by so and so. The response are restrained from putting up constructing any road for the land in survey number 42 of Egre village and Agragon Gram Panchayat, Ankola Taluk, Uttarakhand district. Till the next day, subject to the land not having been acquired till the next date of hearing. See list on so and so. Process fee and copies by end of day 17, failing which interim order will stand automatically vacated.
My lords, I'm appearing for the petitioner, my lords.
Yes.
My lords, I'm challenging the impugned order of, my lords, it is a mandamus, my lords. My lords, the respondents have acquired my land, my lords, during.
Mandamus.
Mandamus, my lords.
The representation given by, what is your representation?
My lords, the representation regarding the withdrawal of award amount, my lords, which is produced at annexure A, my lords. 3/8/2023, my lords, the honorable arbitrator
Annexure
has.
B is for
representation. No, my lords, withdrawal of award amount, my lords.
Kindly deposit the amount in my bank account. By enhancing the award amount up. I'm submitting.
No, my lords.
passed by the arbitrator, Deputy Commissioner Belgavi by Nancy. Where is the award?
My lords, award at annexure A, my lords. Award copy, which is running at page number 19, my lords.
You have to file execution.
My lords, from the date of 2023, my lords, till date, my lords, they have not given any amount, my lords.
What have you been doing? Have you filed execution?
Not
It's
yet, my
not a
lords.
mandamus. You can't file a mandamus for executing an award.
No, my lords, but even after visiting so many times, my lords, they are just saying, keep on just dragging the matter, my lords. Just,
What are you doing? You should have filed an execution petition immediately.
But my lords, they have instructed us that not to file any petition before any honorable authority, my lords. They are just saying, my lords.
Follow their instruction. They won't pay you any money.
That is the reason, my lords, the petitioner has approached before this honorable court, my lords.
And can't do that. Learned AGA accepts notice for respond number 1 and 2. Shri Yarappa idu NHA.
BP Matpati. BP
Matpati for respond number 3 and 4. Petitioner is before this court seeking for the following reliefs. The mandamus sought for is for consideration of a representation submitted to the NHAI for payment of the amount awarded by the arbitrator in the award passed under section 3G of the National Highway Authorities Act.
Yes.
The petitioner is required to file execution proceedings to execute the award passed by the arbitrator. A writ petition for mandamus not being maintainable, reserving the above liberty, the petition stands dismissed.
Much of it.
The office of regarding that the respondent has the petitioner not made as the party who is in the proceedings before the DC. That is page number 51, my lord. The 41. The fact of the case is, my lord, the petitioner is a purchaser. The land purchased by the respondent number 7 and 8, my lord. In the meanwhile, the one more.
Who are not made parties?
The respondent who is read as a respondent number 2 to 6, my lord. I am the purchaser from the seller is this respondent number 1A, my lord, Shaileja.
2 to 6, Srimati Shweta.
They are sisters. They are sisters of the.
So how can you not make them a parties?
The who is the petitioner before the DC? She is not concerned to that properties, my lord. She is the out of the family.
So you have to make them parties.
I am the purchaser from that Shaileja.
You are not purchaser from Shweta,
I'm not a
Savita, Shambhulinga, Rachana, and you are not purchased from them.
But my name is, I am not allied as a party who before the DC, my lord.
Can we pass an order without them being there?
Please.
By reopening it?
Will
Council, the council submission in respect of office objection at CL number 24 is rejected. Council for the petitioner seeks for and is granted a week's time to file necessary application to implead. Respond number 2 to 6 before the Deputy Commissioner in the impugned order dated 14/12/2024.
During the course of the day. During the course of the day.
17th.
Well, during the course of the day will
file ಮಾಡಿ list put up ಆಗುತ್ತೆ.
There's another matter which needs to be connected, my lords. WP number 1000066 of 25.
With so and so, a week's time is granted to
on 18th, my lords.
Office objection. If office objection are not complied by 18th, the petition would be liable to be dismissed for non-prosecution.
Please.
in the 60, my lord, may permitted to comply that office objection, my lord.
Your office ಯಾವುದು 62 ಅಲ್ಲ
60 my lord,
60 ಆಯ್ತಲ್ಲಪ್ಪ ಏನು ಆಫೀಸ್ objection ಇರೋದು ಒಂದೇ they have not made a party, so you have to file a impleading application.
This is the in the stage of office objection, my lord. Will comply, my lord.
You have to file a impleading application. You can't do that. Yes, Mr. Mardi. 28. Issue notice to the respondent, returnable by, emergent notice returnable by 24th March.
Serial number 63, may I request?
63.
My lords, during end of the day, my lords, I'll do the needful, my lords. Difficulty what I'm facing.
Put ಬನ್ನಿ.
Please, sir.
Serial number
Payment
65.
ಮಾಡಿದೀನಿ ಅಂತ ಬಂದು ಹೇಳಿ.
Serial number 65, my lords. Monday or Tuesday, my lord, because part of file is missing. I've informed 65, Monday or Tuesday, my lords.
ಎಲ್ಲ ಇರ್ತಾರಾ ಅವತ್ತು?
Serial number 98, my lord.
65 released on Tuesday.
Serial number 41.
Yes, Mr. Shetty.
Serial number 98, my lord. Appearing for Mr. K. Anand Kumar, my lord.
Yes.
Next week, my lord. He has some personal inconvenience, my lord. 98, my lord.
K. Anand Kumar, ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತೀರಾ ನೀವು?
K. Anand Kumar, Swami.
98 at the request of counsel for the petitioner released on 7th March.
Interim order, extend Monday.
Order earlier granted is extended next week.
In the morning, in serial number 6, notice is ordered by granting interim order. May I seek for dispensation of notice to respond number 3 to 10, since they are also the defendants and it is defendant's petition.
Take notice.
Serial number 8. Serial number 8. IA had not been filed for.
Told. IA so and so is allowed.
Serial number 41, Your Lordship. Apology, we could not appear them in the matter, Your Lordship. The parties are trying to settle the matter, Your Lordship. It may be,
41.
please, Your Lordship. It may be referred to mediation, Your Lordship.
Process fee in
We have,
service agilla.
today we have taken.
So they, until they are served, how do we refer to mediation without parties being here? Pay the thing, let them come.
Interim order may kindly be extended.
41 interim order.
Serial number 88. Serial number 88, my lords.
88.
May request for Wednesday or Tuesday, my lords. Since, my lords, afternoons I have some difficulty, my lords.
You have to reach agalla. 88 at the request of counsel for the petitioner released on 14th. Interim order idea?
Yes.
14th March interim order earlier granted is extended till next day.
My lords.
One not?
5.
Five. Yes.
On Monday, my lords.
Either or Monday.
Please. I have filed memo for disposal, my lords. It may reach on Monday, my lords.
Respondents idara, counsels idara Monday.
Intimate ಮಾಡಿದೆ. Monday no other.
105 Monday.
Please.
Yes.
My lord, sir. Serial number 97, my lord, sir. I request for next week short accommodation.
97. Inform ಮಾಡಿದಿರಾ?
My lords, I will inform, my lords.
Will ಬೇಡ. I will inform only after informing.
But serial number 71, my lords. Request
70?
for next week, my lords. 71, my lords. I've informed the other side, my lords.
You have informed?
Please.
But notice has to go to respond number 1 and 2.
71, my lords.
71.1. Issue court notice to ಇಲ್ಲ ಇವರು ಅಪಿಯರ್ ಆಗಿದಾರಲ್ಲ ಶ್ರೀ ಶಿವರಾಜ್ ಬಳ್ಳೊಳ್ಳಿ and Ramesh Zirli, who have appeared for the petitioners in WP 100264 of 2017 are directed to accept notice for respond number 1 and 2 in MSA 1000058 of 2015. Registry is directed to print their names as such. At the request of counsel for the petitioner released on 14th.
Please.
Lord, serial number 53. Lord, it is passor. Since there was a direction to comply, 10 days time again. 10 days time.
ಅಷ್ಟೊಳಗೆ ಎಲ್ಲ ನೋ ಕಾನ್ಫಿಡೆನ್ಸ್ ಮೋಷನ್ ಮುಗ್ದೋಗುತ್ತೆ.
ಇಲ್ಲ ಅದಕ್ಕೆಲ್ಲ that order has been communicated. We have not received any information. So for that reason.
53. And AGS seeks fund is granted a week's time to report compliance. Released on 21st February.
Please.
ಯಾವುದು? 111. Heard in 111. A perusal of the order sheet indicates that the matter has been heard in part by coordinate bench. Registry is directed to place the matter before the coordinate bench.
Sir, 52.
230 mood matter. 1 Prashant Kardevar.
Yes, Mr. Card.
For the petition. Sorry. Lord, we have, my Lord, filed application, my Lord, stating that, my Lords, the trial court, my Lord, the labor court is not having a jurisdiction to entertain the petition filed by the respondent. For the reason that, my Lords, kindly see, my Lords, annexure A, Lordship, page number 16, 15, and I have to copy at page number 16. Lord, on 24/12/2021, the respondent workman has been transferred from Gadag to Jogihalli village, which comes under the, my Lord, jurisdiction of the Chitradurga district, your Lordship. And, my Lords, the termination order.
Jogi Matti alva.
Jogihalli. Yes. And annexure B is the termination order passed on 31st May 2022, which is under challenge at annexure C before the, my Lord, Principal District and Sessions Judge, Lordship, at Gadag. And therefore, my Lord, we have filed, my Lord, application saying that, my Lord, the court situated at Gadag is not having a jurisdiction to try the matter because the termination order, my Lord, passed, my Lord, at, my Lord, Jogi, when he was in the Jogihalli village, which comes under the, my Lord, district Chitradurga. And accordingly, my Lord, issue number 3, my Lord, has been framed at page number 38, annexure E, whether this court has jurisdiction, territorial jurisdiction to entertain and try and dispose of this petition. That has been, my Lord, passed, my Lords, at page number 69 in affirmative. That is under challenge before this honorable court. My Lord, in an identical matter, it's covered by decision, Lordship. Kindly, may I pass on this?
Yes.
Please. Lord, the thing is, Lordship, Lord, the transfer order annexure A, my Lord, it's.
You are not based in Chitradurga.
No, no. What I am trying to say is, even though trial is conducted, at the end of the day, Lordship, the court is not having a jurisdiction. That is what my submission was.
It doesn't matter to you whether it is Gadag or Chitradurga. Go there. You are only delaying it. Issue notice to the respondent. Returnable, emergent notice returnable by 11th March. The interim relief sought for will be considered after appearance of the respondent.
Please.
2 Abhinandan Hiremat.
My Lord, respectfully, I request you to move to the page number 72, that is hand sketch, my Lords, which shows the properties.
You are the plaintiff.
Please, my Lords.
Suit
Plaintiff's
for?
petition. My Lords, suit for a permanent injunction, my Lords. Here, my Lords, there are 4 properties, my Lords. Now the suit schedule property is 551/B. It is a petitioner's property.
Injunction order before the trial court which was vacated in the first appellate court.
Please, my lords. And in the miscellaneous appeal, my lords, the appellate court opines that already there is a erection of the building that is up to the stage of the window. And they says, my lords, there is an erection of the building by defendants. If at all there is an encroachment on the plaintiff's property, let it be identified and established before the trial court, and it may be removed at the later stage. My lords, to prevent the future possible injuries, my lords, the temporary injunction was very much necessary, my lords. The appellate court, which the order was passed, my lords, it was unfair. The temporary injunction which was granted in the favor of the plaintiffs, my lords, and one more thing, my lords, the annexure G, there was a notice. There was the notice issued by
photographs of the construction.
It was produced in the suit, my lords. It is not produced here, my lords.
There was an injunction order. Issue notice to the respondents, returnable by 17th March. The order dated 5/2/2025, passed in MA number 8 of 24 by the Senior Civil Judge and James Shigaon at annexure E. He stayed. Consequently, the injunction order passed in OS number 54 of 2024 on IA number 1 stands restored. Process fee and copies to be furnished by end of day 17th February.
Please.
An acknowledgement of service on the counsels for the counsel for the respondents before the trial court to be filed on or before 21st February. Failing either of which, the interim order will stand automatically.
Please, highly appreciated.
3. Veena V.
I am appearing for the petition.
Yes, madam.
Yes, I appear for the response number 3.
My lords, I'm
notice ಕೊಟ್ಟಿದ್ದೀರಾ ಮಸ್ಟ್ ಕಳಿಸ್ಕೊಟ್ಟಿ
ಥರ್ಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್
Notice,
ಪಟ್ಟಣ
yes,
ಪಂಚಾಯತ್
sir.
ರಟ್ಟೆ
ನೀವ್ಯಾರಿಗೆ ನೀವು ತಾನೇ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕಾಗಿದೆ ಯಾರು ವೆಕೇಟ್ ಮಾಡ್ತಾ ಇರೋದು
My lord, that is no auction to be conducted. Earlier occasion they have approached this honorable court in the writ petition. They undertakes to vacate, my lord, on or before 28/8/2022.
These holders of shop.
Shops, my lord, 20, my lord, 13, my lord. Shops, now it is to be auctioned pursuant to the order of the deputy commissioner.
You can
as
participate, madam.
as regular as they have collected the rent and all, my lord. The order has
Yes,
came.
how many years? You have been there for 15 to 18 years.
Yes, my lords.
So
But
you
the
can
thing,
participate in the auction in terms of the circular issued by the state government.
Yes.
my lords, the minimum 15
you-
days of show cause is not.
No need to show cause now. First, you can participate in the auction, or you can decide to exercise your right to first refusal. If both of them you fail, then they'll take action under public
My
premises
lords,
act.
their condition is that we need to vacate first. But the thing, this is not a, this is the city, it is not a town, my lord. It is a label as town, but it is still village. We are unable to vacate. There is no multi-store shops
No,
there
we-
for vacating itself, my
You
lord.
don't need to vacate. Don't vacate. If they participate in the auction and succeed, they don't need to vacate.
If they become successful bidders, they will continue, subject to the
Or right to first
terms of the
refusal
condition.
exercise ಮಾಡಿದ್ರೆ, they'll continue.
If they failed, my lord, then they have
If they fail, then public premises act.
But
And AGA accepts notice for respond number
my lord,
1, 2 and 4.
one submission, at least for 15 or 1 month, the time has to.
ಇನ್ನ ಜಾಸ್ತಿ ಟೈಮ್ ಸಿಗತ್ತೆ ನಿಮ್ಗೆ ಈ ಆರ್ಡರ್ ಅಲ್ಲಿ.
Yes.
1, 2 and 4. Shri S.G. Kadarkatti accept notice for respond number 3. The petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that without initiating proceedings against petitioner under the Public Premises Act, the petitioners have been asked to vacate the premises leased, occupied by them under lease under the third respondent. Para.
Annexure.
ಇದಲ್ಲಪ್ಪ, not this.
Blood earlier.
Circular.
Circular, blood, it is not, then blood is 2015, my lord, that is for a period of 12 years, subject to the enhancement of 10% for every 3 years, that is.
Learned AGA. submits that the petitioners have been asked to vacate the premises in view of the proposed auction to be held in furtherance of the circular dated so and so. Please. And as such, no fault could be found therewith. Having gone through the circular dated so and so, it is seen that that in terms of circular, a tenant occupying the premises leased by a village stroke town panchayat or a municipality has an option to participate in the auction proposed to be held by the said authority. And in the event of the tenant succeeding in the auction, the tenant will continue to have a right, can continue to be in possession of the premises in question, since the respondent would be obligated to execute necessary agreement in terms of the said circular.
One more submission. Already they have paid 50,000 rupees of the advance, my lord. They are not returning that as.
ಇದು ಬೇಕಾ ಈ ವೆಕೇಟ್ ಮಾಡಬೇಕಾ?
No, Swami. Allah.
ಹೇಳೋದು ನೋಡ್ರೆ ವೆಕೇಟ್ ಮಾಡಕ್ಕೆ.
My lord, that is also an option. That.
In the event of the tenant not participating in the auction proceedings, the tenant also has a right to exercise his right of first refusal upon the auction being completed by making payment of some 5%.
10%, my lord, for every 3 years enhancement.
Mr. Kalsurmat.
Every third, my lord.
12 years.
10%.
10%.
10% over and above the auction price. If the petitioner if the tenant were to exercise such right of first refusal and agree to make payment of 10% over and above the auction price, the respondents would be obligated to execute necessary lease documents in favor of the tenant as per the terms of the auction. Thus, it would be premature now for the respondents to seek for and direct the petitioner to vacate the premises until the completion of the auction proceedings and the exercise of the rights confirmed under circular dated so and so by the tenant. It is only if the petitioner were not to participate in the auction, or if participating in the auction not being successful, or if having not participated in the auction and not exercised the right to first refusal, then the respondent would be entitled to take such action under the Public Premises Act as may be applicable. In that view of the matter, I pass the following order. Writ petition is allowed, a certiorari is issued, the order dated so and so at Annex B and C is quashed. Liberty is reserved to the petitioner to participate in the auction.
Annexure C auction notice, that is notification, not the, we have not issued any notice. It is a publication, auction publication notice.
Annexure B is quashed.
Yes.
The petitioner is permitted to participate in the auction to be held in terms of Annexure C. As per the observation made here above.
Machu.
Court fee ಕೊಟ್ಟಿಲ್ವೇನ್ರಿ?
Three members are there. We have paid 3 court members, 300 rupees. Maybe they have confused my.
1, 2, 3.
Yes, my lord. I will comply that objection.
Yes.
Four, Gayatri, yes, sir.
Petitioner is calling in question order dated 12/2/2025 passed by the trial court. Mullets, the respondent father herein had filed a suit for declaration and possession of the suit property to an extent of approximately 4 guntas. The same was decreed. The petitioners had called in question the same mullets and the RA was dismissed. They filed an RSA mullets. RSA is also dismissed. Now mullets, the commissioner was appointed to measure the land mullets. However, he has shown in Annexure F, my lords, there is an encroachment to an extent of 5 guntas, 12 annas. Now the executing court has directed me to hand over the possession to an extent of 5 guntas, 12 annas, which is more than the preliminary decree.
Where is the preliminary decree?
Preliminary decree is at page 57, A2, my lords, annexure. Davasti
Page number?
Varnane.
Page number?
Page number 57.
Suit property description only there.
Please, my lords.
Where is the suit property description?
That is the only description, my lords. In the plaint also they have described the property as seen.
Then you can't say 4 guntas.
Let's,
Yes, it was.
I'll show it from the records that it is only 4 guntas. Your lordship may peruse plaint at annexure A, page 19. Davasti Varnane.
Yes.
ಶಿರಸಿ ತಾಲೂಕು ತುಡಗುಣಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 93/2 ಕ್ಷೇತ್ರ 8 ಗುಂಟೆ ಆಕಾರ 1.41 ಪೈಕಿ ಪೂರ್ವ ದಿಕ್ಕಿನ ಅಜಮಾಸ 4 ಗುಂಟೆ. That is the extent they have claimed. Suit is also decreed in to an extent of 4 guntas. Even the executing court also holds that the decree is in terms of only 4 guntas.
Issue notice to respondents returnable by 9th April. The operation of the order dated 11/12, 11/2 na?
2 minutes.
11/2/2025. Passed by
Principal Civil Judge
Principal Civil Judge,
and First Additional JMFC Court, Sirsi.
Additional JMFC ಯಾವುದು?
Sirsi.
Sirsi. He stayed insofar as the land in excess, area in excess of that mentioned in para 1 of the plaint in OS number
OS number minutes 9 of 2002.
9 of 2002, then pending on the file of the Civil Judge Junior Division Sirsi. Process fee and copies to be furnished by end of day 18th, 19th. 19th. Failing which the interim order will stand automatically.
Great.
5. SS Bitturmat.
Permitted to withdraw them. Petitioner is before this court seeking for the following reliefs. A memo dated 14/2/25 has been filed, signed by the chairman of the petitioner society and the counsel for the petitioner, which reads as under. Accepting the said memo and submission, petition is dismissed as withdrawn. Please.
Lord,
113. See her still open.
This fourth respondent had challenged, my lord, the order of assistant commissioner before the first respondent, my lord. The first respondent, my lord, considering the pendency of the RSA, Lord, set aside the order of assistant commissioner.
So he'll withdraw the appeal.
Please.
He'll withdraw the appeal.
They have
withdrawn. I withdraw the appeal, my lord.
He has withdrawn the appeal, my lord. So now this order.
Order will go.
Please.
He has withdrawn the appeal and this is a final order.
Final order, my lord.
Now we'll record a statement that he is going to withdraw. We'll dismiss the appeal as withdrawn.
Yes.
So this order automatically will stand okay.
Yes.
There is arrangement by the party between the parties.
That is a part of memo, my lord.
There is arrangement between the parties who were not parties to the RSA. I am for respondent number 4, my lords, who had challenged the mutation entry before the
district commissioner,
Hmm.
deputy commissioner. That's now there is arrangement, my lords, at page number 2, first agreement of settlement. In view of
Respondent
settlement,
number 4 challenge the order of the assistant commissioner
please,
before the deputy commissioner.
please.
Yes, my lord.
Deputy commissioner has allowed your
Allowed.
challenge,
Yes.
Please,
impugning that they are here.
please.
Now,
Now,
if you withdraw that appeal,
they have withdrawn that appeal, my lords. In meantime,
they are, you have filed.
Other respondents in that they have filed.
My lord,
Now filed.
may I submit?
What has happened, my lord?
One
Before the
nimission,
deputy-
one nimission.
Correct again.
Please, my lord. OS was filed by me was dismissed, my lord.
Hmm.
Lord, appeal was filed. In the appeal, there was a compromise. In challenging the compromise, respondent number 12 had preferred RSA, my lord. He withdrawn that RSA, my lord. So the compromise that has taken place in RA has attained finality. Lord, by virtue of pending of RSA, my lord, the deputy commissioner set aside the order of assistant commissioner. Lord, now the fourth respondent has entered into compromise, my lord.
Who filed the proceeding before the deputy commissioner?
The fourth respondent, present fourth respondent.
I have.
Yes.
That is what we are saying.
Yes.
There is meantime there is arrangement, my lords. It may be treated as part of this.
Who you only you have filed.
I had filed.
You bet in there illa.
Illa, illa.
So if you withdraw that appeal,
Revision.
revision.
Yes.
Automatically.
Lord, by
that,
virtue of this memo, he
now, my lords, by virtue of this memo, arrangement is being made.
Only to protect
between-
the Miller's interest of parties, we have Miller the mentioned the Miller the whatever that arrangement which has Miller's.
This arrangement, my lords, may be taken on record, and the proceedings before this deputy commissioner permitted to withdraw that revision. Andre,
by
confirming
placing
the,
this memo on record, my lord, they let him withdraw the revision. I'm sorry, my lord. I'm sorry, my lord.
See, now you are complicating it by saying that you have entered into an agreement,
Yes.
which is different from the earlier
Yes.
order passed.
Yes.
So now you have two options.
Yes.
One is either we remand the matter to deputy commissioner, where you can record the compromise,
Please.
or you can move the RSA court to record the
Well,
compromise.
RSC is already withdrawn, my lord.
ಅಲ್ಲಿ ಡಿಕ್ರಿ ಡ್ರಾಪ್ ಆಗ್ತಾ ಇತ್ತಲ್ಲಪ್ಪ, ಎಲ್ಲರಿಗೂ ಬೆನಿಫಿಷಿಯಲ್ ಆಗಿರೋದು.
ನೀವು ರಿವಿಷನ್ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಮತ್ತೆ ಅಲ್ಲಿ ಆಗಿರ್ಲಿಲ್ಲ.
ರೆವಿನ್ಯೂ ಕೋರ್ಟ್ ಬದಲು RSC ಅಲ್ಲಿ ಡಿಕ್ರಿ ಡ್ರಾಪ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ. ಸೆಟಲ್ಮೆಂಟ್ ಇಲ್ ಬಿ ದೇರ್ ಆಸ್ ಎ ಡಿಕ್ರಿ ವಿಚ್ ವಿಲ್ ಬಿ ಡ್ರಾನ್ ಅಪ್ ಫಾರ್ ಆಲ್ ಯುವರ್ ಬೆನಿಫಿಟ್.
Instead of that, my lord, if he withdraws the revision, since
ಶಾರ್ಟ್ಕಟ್ ಆಗುತ್ತೆ ಶ್ರೀಯರ್ಷ್, ಡೋಂಟ್ ಡೂ ಎ ಶಾರ್ಟ್ಕಟ್.
To get the decree.
Get a decree. We'll keep this pending.
Yes.
No worries on that. Well, next week we'll have it. ನಾಳೆ ಮೂವ್ ಮಾಡಿ RSA, Monday or Tuesday, Wednesday, whenever.
RSA.
Move the RSA, submit a compromise, get a compromise recorded. That we'll accept it here and dispose of as in terms of the decree passed in RSA.
Ali, Lord, why, Lord,
There is a problem.
they have challenged the order of Lok Adalat in RSA, Lord.
RSA.
So RSA itself is not
Technically, Millar's it
maintained.
is not.
Technically, it is not.
We are entering into a compromise.
Allah,
The jurisdiction.
With the lordship's, if my lord permits, my lord, if this joint memo is placed on record, my lord, if the in view of withdrawal of RSA, if the order of deputy commissioner is set aside, the whole issue will be, because he is agreeing with the confirmation of order of assistant commissioner, my lord.
But your change in the holding will come about. Petition number 1 for 1 acre 3 guntas, 2 for 1 acre, 4 for 2 guntas, 12 for 1 gunta.
Yes, my lord.
So this arrangement has to be recorded somewhere. Some order has to be passed. Very withdrawal gagala. We'll have it on Tuesday. All of you think about it. Arrive at a proper solution so that the interest of everybody is once and for all closed.
Please.
This methodology may not work.
Please.
Urgency and beda.
Yes.
They have fought till RSA. They can wait for some time, but do it properly.
Please.
Just take the memo on record. We'll have it on Tuesday, Monday, Tuesday, either.
Yes.
Tuesday.
Tuesday.
The joint memo has been filed. The same is taken on record at the request of all the councils, relist on 18th at 2:30 p.m.
Please. And recent decision of Honorable Apex Court, Revenue Court has no jurisdiction to enter the compromise. Please.
RSL ಮಾಡಿ ಅಂತ.
ಅದು withdrawal ಆಗಿದೆ. It is withdrawn before Honorable Justice.
We are also acting in furtherance of that. We are acting in furtherance of a revenue proceeding.
Yes.
Though as a writ court.
Yes.
So our jurisdiction is also in furtherance of the 136(4).
226, Your Lordship can.
226, we can't substitute everything. We are restricted by our roster. If we are handling RFA, our appreciation is different.
Please.
RSA different, writ petition different. So RSA, ಏನು problem in RSA?
RSA has been withdrawn, Lord, before Honorable Justice Hemlekam, Lord. He is sitting at Bangalore. So now I should file an application for recalling of the order.
You can always move.
Please.
You get a decree in RSA, it will put a dent. Revenue court bad. It won't help you. It won't help everybody.
Please. Please.
Not but it.
Please. Oblige.
After hearing 112,
Let's,
V. Somapur.
may I make one mention, Mulats? I'm sorry, Mulats. May I request for hand delivery? It's a dwelling house.
Hand delivery. Yes, 712.
Great.
The direction will not to furnish the report. You have furnished.
Oh, this is that reviewer pet.
Yes.
Sunday market.
There are, I've seen that report, Malad. That admittedly there are violations. That I don't think there was.
Can you rectify that?
Yes, Malad. I think that's where I'm at now. I'm told, my lords, the adjoining property, which is now, I think it's just waiting for registration because there was some PID number which is awaited. Possibly some of them to an extent can be regularized once that adjoining property also is taken into account, but I'm not in a position today to say exactly how much can be regularized. So therefore, in fact, as a matter of abundant caution, we also filed a new plan sanction, in fact, for modification of plan sanction that's pending. But of course, that can't be considered until that adjoining property is actually registered. And so that I'm told, registration. No? Next week, registration agatante. Then after that, possibly.
Don't carry out any further.
No construction. Absolutely no construction.
No electricity connection, no water connection, no occupation.
It's already occupied, I think.
Not occupied. It is empty.
It is occupied.
It is empty.
Huh?
All empty.
No, basement we will not occupy.
All occupied, madam. Here I am producing that I am filing objections to the commissioner report and commissioner has carry out the inspection of the petitioner's property and I have produced I have given a letter also to the commissioner, SDMC commissioner, and I am producing the photocopies. The damage caused to my property at the time of
Stop using this property.
And also, I am relying on a decision of Apex Court. Though there is a, let them furnish a copy to me. Yes. That objection copy, my lords, which he has filed against objection. The report.
Judgment.
Is a copy to. Okay, sorry.
Namde yadu.
You have to stop using the property.
Sorry, what?
You have to stop using the property.
The basement, I'm told, was, that there is no one is using
The
that.
entire building is bad, Mr.
And basement they are using as a commercial shops. I have produced that.
So that will close. Basement will close.
You have built wall to wall. While building that, you have destroyed.
No, that, my lords, I'm told that there is some, they'll settle it, my lords. Whatever amount is there, that payment will be.
Go forward and pay.
Yes. I'm told 2.5 lakhs has already been paid, and another.
He has executed 2 agreement deeds saying that he will construct my building as it was earlier, and he will repair that building also. But the entire building has been collapsed. That is first floor they have removed even without my consent. The entire first floor has been removed.
Because there are 2 ladies. Your client is running roughshod over them. What do you want to do?
Once we file the application, once the adjoining property is purchased.
First, what is the?
From beginning, 2018, from beginning, I am giving letters to the corporation authorities also.
I think can
be agreed to construct it as it is, construct it and give it. You don't want to get into with proper
as it
material.
was then, my lords, when the.
And he has agreed till construction of my building, he will pay 20,000 rupees as rent because 3 shops are there.
Writingly the agreement.
3 shops are there.
Writingly the.
Writingly.
What do you want?
That I produced that agreement. He has executed. He himself has executed that agreement.
Whatever is in writing, do that.
Yes. We'll get it repaired, my lords. Whatever, we'll restore it, my lords. Whatever it was then when the damage happened, that, my lords, may record.
Agreement has been arrived at, do it.
But I'm not sure what that agreement was for. Agreement.
And until the modification happens, that's no use of the building.
This is the agreement deed.
What are your copies?
Annexure D in the writ petition I have produced.
Your lordship may record on instruction of submitting that whatever there will.
So on whatever the agreement is, you will comply. You will apply for a modified.
Applied already.
Yes, that will be rejected tomorrow.
That will be rejected and
they consider it. So you will stop using the building until the modified plan sanction is issued and you rectify as per that modified plan sanction.
But only the part of the building is, I mean, even the violations shown are not 100%. Basement will completely stop. Basement is 100%, that will stop.
Yes.
To whatever extent.
Basement and 4th floor, terrace. Without permission, they have constructed.
You comply with all of this, we will permit you to use.
That will have to comply once that adjoining property is, then to whatever extent.
Is your choice. You want to do it today, tomorrow, or 1 year down the line.
It's already occupied is what I'm told. To
then,
vacate.
No usage of the building. When you complete it, you let us know, we will allow you to use the building.
So I'm told only.
Or we will direct them to demolish, that's all. We are giving this leeway if you are the client thinks.
No. I'm told again, basement will, he's ready to close. There are tenants over there, so that may.
Demolish it.
There are 10.
Without obtaining completion certificate, they are using the property also.
We can take the horse to the water, or you can also take the horse to the water. You can't make it drink.
Without, even entire building has been given on.
Only Mr. Gachinmat will get his JCBs now, that's all. On a Sunday, when Ravivar Pete is on a holiday.
Petitioner will be happy to pay for 2 more also. The petitioner will be happy to pay for 2 more JCBs also to expedite it. Anyway, I don't think we have an option now.
Do it fast.
We'll do it.
So both of it parallelly, you finish the agreement, finish the modifications, and then use. Until then, don't use.
not left
We'll
with any
disconnect the
option.
electricity and the water, so that no tenant can use it.
But all I'm saying is that, Manoj, yes, admittedly there are violations. I'm not in a position to deny those. But Manoj, there are 10 tenants over there. Now there are violations. So if we could be given some breathing time until that is, otherwise, Manoj, I'll have to ask them to vacate. But he wants his pound of flesh. He's getting his pound of flesh. I understand what the petitioner wants, but all I'm asking for.
We are not concerned with what he gets. We are concerned with the rules being
Correct, Manoj. If there is a violation, there is a violation.
And the other, this one about Mr. Gachinmat's officers, that also is still left. That is not going to go away. Once they do what they are required to do, these kind of things need not happen.
Submission, since 2000 is from beginning itself, I am giving letters to the corporation also. They are also not taken any action.
ಇವಾಗ ಆನ್ಲೈನ್ ಇದಾವೆ ಗ್ರೀವೆನ್ಸ್ ರಿಟ್ರೆಸಲ್ ಇದು ಆನ್ಲೈನ್ ಹಾಕ್ಬಿಡಿ ನೆಕ್ಸ್ಟ್ ಯಾರಾದ್ರು ನಿಮ್ಮ ಕ್ಲೈಂಟ್ಗೆಲ್ಲ ಹೇಳ್ಬಿಡಿ ಯಾವ್ಯಾವ ಟೈಮ್ಗೆ ಹೋಯ್ತು ಅಂತ ಅಲ್ಲಿ ಬರುತ್ತೆ. ನೀವು ಪೇಪರಲ್ಲಿ ಕೊಟ್ರೆ ಆ ಪೇಪರ್ ವೇಸ್ಟ್ ಬಾಸ್ಕೆಟ್ಗೆ ಹೋಗುತ್ತೆ. ಆಮೇಲೆ ನಮ್ಗೆ ಏನೋ ಕಂಪ್ಲೇಂಟ್ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
I have received the acknowledgements are there. I have received. I am
ಕಂಪ್ಲೇಂಟೇ ಬಂದಿಲ್ಲ, ನಾವೇನ್ ಆಕ್ಷನ್ ತಗೊಂಡು
bundle of papers.
ಬಂದಿಲ್ಲ, ವೇಸ್ಟ್ ಬಾಸ್ಕೆಟ್ ಅಲ್ಲಿ ಹೋಯ್ತು ಅದು ಕಳ್ಳೆಕಾಯಿ.
Could we be given some breathing time to vacate then?
The breathing time.
I'm requesting about 30 days.
No problem.
30 days.
How long will you take to rectify that?
We will vacate it and within 30 days, and at the same time let the corporation process our.
Yes, we'll vacate in 30 days. But that undertaking will be recorded. And in the meantime, if it's not regular in the meantime, 30 days, there's no option, but we'll have to. If in the meantime the corporation takes a call on our application, then to whatever extent is regularized, then we'll be in a position to.
We are ready to take it tomorrow.
No, but as the lordship rightly pointed out, tomorrow ours will be rejected.
Everything is in your
Get
hand.
rejected. It'll get rejected.
Not there.
No, I don't think registration. It's told is at the last stage. This registration. So once it happens by next week.
A report of a memo enclosing the report of the HDMC is filed. The same is taken on record. The report indicates several violations on part of the respond number 4, requiring action to be taken by the HDMC. However, taking into consideration the submission of Sri Vikram Oilgol and Senior Counsel that that a portion of the adjoining property is being purchased by the respond number 4, which on purchase would make available certain additional land so as to that the alleged violation, so that the violations as regards the setback would stand rectified. His further submission is also that any damage which has been caused to the property of the petitioners would be rectified in terms of the agreement arrived at between the petitioner and respond number 4, so that all terms are complied with. He seeks for 30 days to enable respond number 4 to complete the purchase of the adjoining property, submit a application for modification of the plan sanction, as also to carry out such rectification of the building already put up as may be required to comply with the report submitted by the HDMC dated 10/2/2025, which has been taken on record today. Though there are violations of the violations by respond number 4, and though it is easy to direct the demolition of the building, I am of the considered opinion that the interest of everyone needs to be protected by arriving at a viable solution for all concerned. As such, the submission of Sri Vikram Muilgol and the senior counsel is accepted. 30 days time is granted as sought for. Within the said 30 days time, respondent number 4 would have to comply with the agreements arrived at with the petitioners and obtain a modified plan sanction from the HDMC. On such modified plan sanction being issued, the HDMC is directed to once again inspect the said premises to ascertain if the construction is now brought in compliance with the modified plan sanction. If the same is not done, if this above is not completed within 30 days from today, that is on or before 17th March 2025, the HDMC would be at liberty to take such action in furtherance of the inspection reported at 10/2/2025 as available under law. What about your officers?
Please. The notices are issued, my lords, to the concerned officers. The notices are issued. Now, my lords, we are awaiting the reply of those officers.
Shri Gurudev Gachimad, the counsel appearing to the HDMC, submit that a show cause notice has been issued to the concerned officers and their reply is awaited. Once the reply is received, further action will be taken. The Commissioner HDMC is directed to issue necessary instructions to all the engineers and planning members.
That's to all the zonal assistant commissioners and the office of the deputy director of town planning.
ಅದು ಬಹಳ ಹೈ ಲೆವೆಲ್ ಆಗೋಯ್ತು ಎಲ್ಲ. Who is the ward engineer?
Commissioners, my lords, will issue permissions for residential.
Permission allappa. Who is the ward engineer again? Junior engineer?
Commissioners themselves will initiate the proceedings under section 320.
Who is to bring it to notice? Who is the junior most engineer in the ward?
Junior engineer. Junior engineer.
Instruct, issue necessary circular directing all the engineers at the ward level
Please.
to carry out regular inspection of the buildings being constructed in the said ward and to bring to the notice of the assistant, who will have to issue the notice?
A zonal assistant commissioner.
Zonal assistant commissioner of any violation during the process of such construction, so as to enable immediate action to be taken. When such immediate action is taken, it would not be required for the HDMC and or for this court to direct demolition of a building which has been built using the resources of either private party as also using the resources of a private party. If any violation were to be brought to the notice of the assistant commissioner, necessary action to be taken by him by issuance of necessary notices under subsection 1 of section 321 of the Municipal Corporation Act as early as possible. If no action is taken, the commissioner would be at liberty to initiate disciplinary proceeding against such officers. We list on 21st March.
A couple of submissions. One is, I'm told, your lordship said within 30 days for the modified plan sanction to be obtained. Because if I file my application, the officers delay it, then I should not be.
No, we will consider tomorrow itself, my lords. If
No, my concern.
Repeat,
That's one. That second
when
concern.
will you apply for the modified plan?
Yeah, other reject agatri. I think we'll apply for it.
Afresh, they will have to apply
Apply
afresh.
afresh.
You have to include that property and then apply.
That property, then they will have to apply. Then alone. my lords,
ನಾಮಕಾವಸ್ಥ apply ಮಾಡಿದ್ರೆ ಅದು ನಾಳೆ ರಿಜೆಕ್ಟ್ ಮಾಡ್ತಾರೆ.
Already they have.
ಅದು ಮಾಡ್ಬೋದು.
ಯಾವಾಗ The other concern was, I'm sure they're worried where the petitioner may not cooperate when the agreement is being this thing. So that also, if my learned friend can assure, I'm sure. I'm aware of it.
Cooperate out.
So Somapur is there, you will get them to cooperate.
Every time we are.
If you don't cooperate, then we will terminate the agreement.
We are cooperating every time, but they are.
ಇವಾಗ ಆಗಿದ್ದಾಯ್ತು. Now.
And
ಜೋರ್ ಮಾಡಕ್ ಹೋಗ್ಬೇಡಿ, ಕೋರ್ಟ್ ಇಂದ ಆರ್ಡರ್ ತಗೊಂಡ್ ಬಂದ್ವಿ ಅಂತ.
ನಾವು ಕೋಆಪರೇಟ್ ಮಾಡಿ ಪ್ರತಿ ಸಲ ನಾವು ಅವ್ರಿಗೆ ಕೋಆಪರೇಟ್ ಮಾಡಿದ್ರು
10 days
the submission of the learned senior counsel that the modified plan sanction to be submitted within 15 days from today is placed on record. If such application is filed, the HDMC to consider and act upon the application
in accordance with the relevant bylaws.
In accordance with the relevant building bylaws within 15 days from the date of such submission. 30 days thereafter is granted to the petitioner to rectify the building as per the modified plan sanction granted. Released on 21st April.
Grateful.
Released on 21st April, 21st March to consider the progress in the matter.
Very good. Great.
ಹಂಗೆ ಬಿಟ್ಬಿಟ್ರೆ ಆಗಲ್ಲ.
21st March. Grateful. Just one mention, but serial number 66 also I'm appearing in. I'm sure that I don't think even I will have the time. So it could be taken up possibly sometime next week or 20th or 24th.
66 released on.
Subject to your lordship's consent. 20th even for
24th.
24th I'll take it.
69. Grateful. That's urgent matter. 2011 matter.
ರೀಚ್ ಆಗಿ ನಿಮ್ ಹೊಸ ಫೈಲಿಂಗ್ ಜಾಸ್ತಿ ಇದೆ.
18th or 19th.
Serial number 110.
18th we have 100 matters, 19th we have 93 matters, 20th we have 96 matters.
At least next.
Already listed plus 50 ಹೊಸ ಫೈಲಿಂಗ್.
Next
ರೀಚ್ ಆಗಲ್ಲ.
next week.
20th.
No confirmation. Yesterday matter. No confident.
ಏನಾಯ್ತು?
Meeting to be held on 17 minutes.
PDO has a, PDO, not the acting commissioner.
In the requisition, PDO the signature, put his signature, PDO. Yesterday matter, they take time to file.
Yesterday, esto matter.
In the requisition, the PDO put his.
Confidence, ಅಷ್ಟೊಂದು ಬರ್ತಾ ಇದಾವೆ. ಏನಿದು? What is this? Oh, ಇದು endorsement ಇದೆ.
Endorsement.
It is, PDO lordship, it is maybe allowed.
The DG accepts notice for.
ಅಲ್ಲ yesterday ಆಗಿದೆ
ಅಲ್ಲ notice. Notice to respond number 4 to 12 ಹೆಂಗೆ?
Dispense ಆಗಿದೆ.
Counsel for the petitioner has filed a memo seeking for dispensation of notice, but our affected party ಅಲ್ಲಪ್ಪ.
Notice stay
Notice.
ಯಾರು ಇಲ್ವಾ?
Sought for interim order.
Issue emergent notice to respond number 4 to 12 by 11th March. The operation of the notice dated 1/2/2025 bearing so on so issued by respond number 2 at Annexure C is stayed till the next date of hearing. Process fee and copies to be furnished by end of day tomorrow.
Please.
End of day 15th, failing which the interim order will stand automatically vacated. Liberty is reserved to the respondents to move the matter for modification as and when they enter appearance.
And 17th is the meeting, kindly direct me, intimate my appointment.
ಏನಾಯ್ತು?
ಅಲ್ಲಲ್ಲ, intimate.
ನಮ್ಗೆ ನಮ್ಮಲ್ಲ ಅವರೇ ಹೇಳ್ತಾರೆ.
And delivery order.
Serial number 108.
Any date you, the date?
11/3.
Minority institution matter, my lord. In the similar matter, principal bench has passed the interim order.
Similar
It may be taken up on 24th, my lord.
Stay continue. 78 stay continue.
108.
Stay continue ಮಾಡಿ.
Sir, 108 is not, sir.
Sir, ಒಂದೇ ನಿಮಿಷ.